microphones remain off for the entirety of the proceedings, and that although you may be participating remotely, this is a formal court proceeding and should be treated as such. If we have any individuals and have repeated issues with folks unmuting or turning their cameras on, we'll have to expel you from the meeting. And thank you, and we'll be getting started in just another couple minutes.
We're back on the record, all counsel and parties are present. I hope you all had a good break. We're outside the presence of the jury. Right before we took our break, we watched the first 18 minutes, I think, or so of State's Exhibit 5. I understand each defendant is moving to exclude that first 18-minute portion. I'm going to assume that the basis is the same as it was for the previous exhibit that we discussed, but if anyone wants to be heard further, I'm happy to listen. Okay, then I think I understand.
Wait. We've already, has the court made a ruling on State's Exhibit 4 yet?
Yes,
That was the previous.
The court ruled subject to the exact timestamps that I believe comply with the court's ruling, which we can take up after this.
Right. So yeah, so Exhibit 4 was the exhibit where I excluded all of the audio and almost all of the video, save for the portion of the video that relates to the time when Mr. Lewis is seen on the video changing clothes.
So is that from 6:05 to 6:45, or do they have a larger?
I think Mr. Hughey made a cut.
Yeah, I want 6:05 to 12:28. I mean, we can go back to that real quick now, or we can stick with
I would
5.
like to finish
Yeah.
Exhibit 5.
Yeah, let's
do
that.
So my order on Exhibit 4 is what it is. As to the specific portion that may be played without audio, we will circle back to that, but I want to resolve Exhibit 5 first.
Okay.
Understanding that the defendants are taking the same position with respect to Exhibit 5 that they did with respect to Exhibit 4. Mr. Hughey, how about the state?
We are as well, and it's, as I said before, essentially the same arguments. Right. And yeah, I think our main quarrel beyond the arguments we've already made and that the court has already overruled in respect to States 4, I think we would want to go back to about the 16-minute mark on this one. Start about there. Mr. Gibson's depicted coming into the frame and shows where he comes from, and
okay,
between 16 and 17 minutes.
Okay, I'm going to want to watch those 2 minutes again before I give you a ruling on it. So if you're able to cue that up now, let's do that now.
Yeah, why don't we start?
Because
I think it's 1650.
Yeah, but why don't we start at 16 even?
All right.
I mean, State's Exhibit 5 shows my client wandering away when they're.
Okay, I want to watch these 2 minutes and then
Okay.
So I what I understand is that the state wants all of 5. I understand the state is acknowledging the likely ruling as to the first portion of 5, given my ruling on Exhibit 4. What the state is now doing, I understand, is offering, in addition to all of the same arguments that I overruled with respect to Exhibit 4, offering additional argument with respect to those last 2 minutes. So what I want to do is watch those 2 minutes and hear the state's additional argument, and then I'm happy to hear from any attorney on any issue.
And for clarity, this is States 5, which is the Rewound News 2 file. We're starting at the 16-minute, 2-second mark.
And candidly, if the state could narrate for me what they think is happening that's adding to their argument, if we do it while we watch their reviews, I would have pressed pause.
No, there's one side. There's more.
I mean, that's still more than us. Although we do have these cudgels.
Not all of them are gonna fight.
Yeah, and we've got shit like this. So.
You got mace and sticks.
Mace and
I'm not
sticks.
walking over there.
Oh yeah, no, that.
Right there.
He didn't show up till 16:45 after they were talking about mace and cudgels.
While they're talking or after they're
Let's
talking?
go back.
Okay.
Oh, it's not as many as I thought. That's one side. No, there's one side. There's more.
I mean, that's still more than us. Although we do have these cudgels.
Not all of them are gonna fight.
Yeah, and
We've not yet seen Mr. Gibson.
I think we just saw him real quick on the corner.
Oh, yeah, okay.
He's now approaching.
But not part of that conversation.
Mace.
Mace.
Right, yeah. We're
No, there's one sign. There's more.
I mean, that's still more than us. Although we do have these cudgels.
Figuring out all my fight.
Yeah, and we.
yeah, he's right behind.
Yeah.
It's many feet away, Your Honor.
Okay, all right.
And
Not trying to split hairs about where he is, I was just trying to pause it at the spot where he appears on video.
Okay, and that is sort of in the back.
That was sort of in the back, right?
Okay, in about 8 seconds, we'll see Mr. Gibson a little more clearly. Okay, you can keep playing.
I mean, that's still more than us. Although we do have these cudgels.
Figuring out all my fight.
Yeah, and we've got shit like this. So.
You got Mace.
Mace and
I'm not
sticks.
walking over there.
Oh yeah, no, that.
I'm going.
Well, he's putting
Your
his
Honor,
gloves
there's a
on. You know what that
defect.
means.
Wait, where is Steve going? What's Steve doing?
Steve is ready to. I got you guys, okay?
Well, yeah, I mean, that doesn't.
The Lord.
Yeah. There's no way.
That's you, although you are a ginger. I was talking
I'm
about.
half. I'm a daywalker. Ginger beard, blonde hair, that classic Viking vibe.
I never saw scare me.
Hey, Alyssa.
Hey,
How are you today?
pretty good. How about you?
Oh, you know, same shit, different day, right?
I get that.
I missed you. You never told me today.
Oh, Haley, by the way, you got
Oh, what? They're awesome.
Here's my opinion.
Ooh, ginger
Oh, and
snack.
the lighter. Hey, that's all that. No. I'm gonna kill. First of all, the wrong way is
Here.
number two. I don't believe that. Do you think? What do you think? Should we get a pound seat to jail? There's only one way to find out how much we're gonna get. We already know we're here. So I just don't. We don't want to. They were thicker. They were thicker.
Yeah, at ice there were so many more. This is kind of like way.
I mean, isn't there an inside to the bar? How can we tell how many people are here? Okay, I guess, but there's an inside, right? How do we know how many people are here? This seems unwise, and that
I don't very unwise.
I mean, is it just the veterans that don't want to do this? Oh God.
You're gonna be famous. Uh-oh, look at the party!
I mean, I'm gonna let everyone else walk in front of me because I have the camera.
That was the 2 minutes. Is that about where you want? That's about where we stop before judge. This is where it overlaps.
I
with
assume that
other
this is
videos.
where the objections stop.
Technically, we had said 1917 before lunch, but.
Okay.
Close enough.
Oh God.
1917.
1917 is, okay.
All right.
So, understand? Go ahead.
Well, I was just, instead of 16 even, I think we'd say 1645.
Okay. And understanding that the state is making the same arguments that I overruled with respect to, well, I'll just make a cleaner record. For the same reasons with respect to Exhibit 4, I'm making the same rulings for the same reasons with respect to Exhibit 5, and I'm going to exclude all of that video up to 1645. Now let's talk about 1645 to 1917.
In our year, this is between 1645 and 1917. You see both Mr. Gibson and Mr. Schultz kind of combine with this group, to put it that way, and then walk over towards the Cider Riot bar.
Are you arguing for video or audio or both?
Both. I think that's, and the reason I am arguing for both 1645 mark is just past the language about cudgels and weapons that the videographer says.
Okay, it's still, and the videographer is Mr. Allen?
Yeah.
Okay, so there's still an awful lot of commentary from Mr. Allen about what he thinks and whether that's actually what he thinks or not, I don't know, but what purpose does that, what admissible purpose does that come?
I don't think his sort of chatter is relevant. I'm not suggesting
There's more of them than there are of us.
Right.
This
I'm
seems
not
like a bad
arguing-
idea.
Yeah, I'm not arguing that has relevance. I'm just sort of arguing that it's innocuous chatter.
Okay, that it's
Yeah.
not. Okay, understood. Yeah. Thank you. I'm sorry, I misunderstood you, Mr. Hughey. I appreciate it. Does anyone else want to be heard on video or audio or both?
On the audio, we don't think that that's innocuous. We think that's prejudicial.
Okay, is there a position on behalf of Mr. Gibson with respect to the video starting at 1645 without the audio?
We would prefer a start time of 1904. The issue with, if I can, with starting at any video in media res is it's one of those things where it can, by applying, it can make it look like, it can misrepresent the connection of the two of them.
He's standing apart. He's off to the side making a phone call. They're just trying to exploit the fact that he's in the same vicinity and then assert that he's part of the group.
Okay, all right, I understand the argument. Thank you. Mr. Schmantzes, any position, video, audio, or otherwise between, I think it was 1635 and 1917?
The audio obviously would need to be redacted from my point of view, from
Thank you.
the hearsay commentary on a number of different concerns.
Thank you. Mr. Doyle?
I still think that video, the Exhibit 4.
We will go back to Exhibit 4.
And Exhibit 5, I think both video and audio are unnecessarily prejudicial.
Sorry we're going. Thank you, Mr. Doyle.
And I think the video is terrible. I mean, the video is terrible, and the audio is worse.
Okay.
Because the audio is an encouraging and inside. I mean, you know, the audio is just. This is just a let's play guilty video.
Okay. Okay, so having excluded Exhibit 5 up to the, I think it was, and I keep saying this wrong, was it the 1635?
1645.
Okay, to the 1645 mark. I find that the video images from 1645 up to 1970 are admissible. They are not, well, they're probative. They show Mr. Gibson and Mr. Schultz approaching the scene where we're about to have the incident that underlies this case, and it shows how they arrived and who they arrived with. All of that is deeply probative in this case. As to prejudice, in the absence of audio, I don't think there's anything prejudicial about the video. It is the same people dressed the same, heading to the place where the jury is going to see lots of video of those people in that place dressed the same. The audio, I continue to think is a real problem. The audio, which is mostly for the portion we're talking about, sort of a running commentary given by the videographer, purports to state views that may or may not be shared by these defendants or by anyone else in the group, and certainly colors the way one sees the video. The problem is it is colored in a way that cannot be tied to any of these defendants. This is one person talking, again, either espousing his real beliefs or not. To that end, I'm going to allow the video to begin at 1635, but the audio is excluded until the 1917 point.
1645?
What did I say?
35.
Thank you, 1645, and I understand that's a critical 10 seconds, and that would have been a mistake, and I appreciate being caught on it. The state has been consistent that it has been talking about 1645. So 1645, video on 1917, audio on.
That is clear. does that resolve defense issues with states 5, or is there more that would require us to spend time watching any more of this?
Meaning, is there more material deeper in the video that is
right.
objected?
That's my question to the defense, yeah.
It is conceivable that there is additional commentary by Mr. Jantz that is objectionable because he had a habit of doing that. And unfortunately, we are not prepared at this juncture to represent for sure that that didn't happen.
Okay, I'll hear, when you're ready to do it, I'll hear it, but we are getting pretty close to the moment. And so I will live in hope that there are not such occasions. If there are, we'll deal with them prior to the video being played, but it needs to be brought,
Thank you, Your Honor.
at the very least, to the state's attention sometime this weekend, so the state knows what it's doing and knows what it is.
A very high priority, Your Honor.
Thank you. Anyone else want to be heard with respect to Exhibit 5? So defendants' motions, those defendants who moved only against the audio, those motions are granted in full. Those defendants who moved against both the video and the audio from the 1645 point to 1917, those motions are granted in part with respect to the video only and are denied with respect to the video. Let us.
My objection to this entire Exhibit 5, I want to make it on the record that I object to both audio and video of this entire exhibit.
Of the entire exhibit?
Yes, yes.
Beyond the point that we have watched?
Yes, this is cumulative to some of the other videos. There are other videos that are much clearer, that this is just, you know, another video, and that is my opinion, that it is that there is incitement in the video that would have encouraged my people to do things that they wouldn't have done.
In this video that is not in other videos? Is this once we get to the site, is this video, you all know the evidentiary record better than I do. What is in this video from this point on that is not in other videos?
It's a different perspective.
Okay, of the same event.
It's the same event, but certainly capturing different people and
right. Okay.
Yeah.
And I say it's cumulative.
Okay. I can't rule on a cumulative objection without actually watching the rest of this exhibit. The state will provide me with that, and I will get you a ruling. We're not going to do it now on the record. But so that objection, which I understand is Mr. Lewis's alone, will be resolved after I have a chance to watch the remaining 31 minutes.
All right. I would now.
Let's return to Exhibit 4 with respect to the period where I've authorized the video to be played, but the question is, what are the parameters around that? Again, the rule is video around the time for the purpose of showing Mr. Lewis changing.
Yeah. So the state's request is just under 6.5 minutes of that video from timestamp 6:05 to 12:28. Would you mind pulling up states 4, Mr. Kalbaugh, and we can mute the audio to play it in the way the court has ordered that it be presented.
While he's trying to find the spot, Your Honor, we believe at lunchtime we identified the before and after helmet issue, and Mr. Doyle has the timestamps to watch out for.
6:05 to 6:45, I believe.
Thank you.
Yeah, the distinction is that it's also about the gloves, not just the helmet.
Sure, but I understand we're going to watch a longer clip now, and then we'll make decisions.
Yeah. Good here? Sure.
Yeah. How far away is it?
Kill the audio, sorry. Yeah. Yep, that's perfect.
My running objection to this is that it shows people changing and putting on clothes that are not at this witness table, that are not charged.
I will hear you, but I cannot pay attention and hear you at the same time. Who are we going to, Mr. Hugh?
1228.
Mr. Hughey, you will agree with me that in that clip, the first portion sort of cuts back and forth from Mr. Lewis, and as it cuts to Mr. Lewis, it shows Mr. Lewis in the process of putting various articles on.
Mm-hmm.
And then there are a couple minutes there in the middle where the camera is entirely away from Mr. Lewis.
Right.
And then the last, I'm approximating 90 seconds or so, is sort of focused on Mr. Lewis.
Right. Then it comes back, and there's a couple different things that we hadn't seen before. Namely, we get a close-up view of what the gloves are themselves, and as we talk about the probative value of those gloves, I mean, even just arguing about the relevance of the video, counsel was saying, no, Judge, they're soft gloves, they're motorcycle gloves.
Okay.
Which
Talk to me about those several minutes in between where the camera is looking at other people doing other things, wearing other clothes.
Right. I mean, I thought that we had I thought that was part of the court's ruling when I had said, you know, if in the passage of time it cuts away from him and then cuts back and then we see the left glove on,
right,
there's going to be some of that.
But I think the way this, having watched it again, tell me if you think I'm wrong, but the way I see the video is at some point, Mr. Lewis is fully kitted out, and then we just are spending a couple of minutes with other people, and then we come back and he is fully kitted out, and we get the close up, and we get there's just a couple 2 or 3 minutes there that have nothing to do with Mr. Lewis.
Right. But then after that,
right,
the reason we still have to come back to it.
I'm not at the moment talking about whether the after we come back part is probative. What I'm saying is there's a big chunk in the middle that where Mr. Lewis doesn't appear.
Right.
Okay. So there are two, in theory, if I said you get all of the Mr. Lewis footage you want, there would be two. There's an infinite number of ways we could do it, but the two that seem the most logical is we either play that entire thing as one clip, or we cut it off when it goes away from Mr. Lewis for several minutes, and we come back when it goes back to Mr. Lewis.
Right. The reason I'm arguing in favor of keeping it together as one clip is because it's showing the amount of time it takes, that this is the same time and place, and that it was the same change into this stuff. Right?
Okay,
I mean,
I hear it.
Yeah.
Okay, thank you. Does anyone want to be heard?
Oh, I do.
Mr. Doyle.
Apart from argument that all of this is cumulative, none of it should come in. There's a real part where it looks like that Mr. Lewis is the one walking with the American flag and using it as a staff, or I think it was just he was holding it for someone else. And I've watched this, you know, enough that I think I can separate that out. I do not think any jury could separate it out, and I'm terribly afraid that they would think that he was intentionally disrespecting the American flag as opposed to changing into gear. So anything that shows him holding the American flag is another objection upon an objection, if the court knows what I'm saying.
I do. Okay. So there are a couple of things going on. One, I also understand, Mr. Doyle, that you are concerned about the amount of time the video spends on other people who are getting kitted out.
Well, that's more problematical to me because it shows that everyone's getting kitted out.
Okay.
But the only named defendant here is Mr. Lewis, and I just don't know how we can separate that some of those objections out, which they're both valid objections, but they may be at cross purposes.
Okay. All right. Anyone else want to be heard on this issue? Okay. Here's what we're going to do. The objection to the portion with the flag, I think, is and will be denied. It's just simply not prejudicial to the extent that I think Mr. Doyle thinks it is, and I think it's probative because it shows, again, Mr. Lewis having put on the apparel that he is wearing. That said, I take seriously Mr. Doyle's concern that this video spends a lot of time on people who are not Mr. Lewis, carrying batons, putting on helmets with some kind of face protection. And so what the state will need to do is to cut this portion, with the first portion being as the camera goes back and forth to Mr. Lewis, getting outfitted. Stopping once the camera goes away and we know it's going to stay away from Mr. Lewis for a while. And then the state may present a second clip once the camera returns to Mr. Lewis and stays with Mr. Lewis. I would have no problem at trial, as this exhibit is being presented, with a leading question from the state that the second clip is however many minutes after the first clip and is in the same place. I think that's perfectly appropriate.
Okay, we will cut those up and call them 4A and 4B, I think.
Okay. All right. Anything else with respect to Exhibit 4? Mr. Doyle.
In addition to everything else, I would reiterate the motion to sever.
Let's take that up now. Thank you. You may articulate the motion to sever on behalf of Mr. Lewis.
Well, this to show this particular clip, it just is him, and I just think that it's unduly prejudicial.
So, with respect to Exhibit 4 in particular, why would severing, to the extent you believe, I understand you think the exhibit is prejudicial, and I've overruled that exhibit, and you have your issue, you have your record. And how, in addition to just disagreeing with me about that, how does this case being joined for trial with Mr. Schultz and Mr. Gibson's case, how does Exhibit 4 weigh on an additional prejudice to Mr. Lewis?
Well, I'm still going to reiterate the flag, that it shows that he's disrespecting the flag, and at no time.
I'm sorry, Mr. Doyle, I don't think I articulated I understood that objection, I overruled it. My question is, if I sever Mr. Lewis, and Mr. Lewis goes to trial alone, but with the same foundational evidentiary ruling, where I disagree with you with respect to the portion of the video that includes the flag, how are we evading prejudice to Mr. Lewis by trying him alone with that evidence in that case?
I can't articulate it, but I'm just going to have it for the record and sit down.
Very well. Does the state wish to be heard?
Just briefly, Your Honor, I think the record doesn't support defense's motion to sever. It would be, on this record, probably a poor use of discretion. If anything, I think the other defendants might be wanting to move to sever from Mr. Lewis based on the evidence as so far it's been presented in these motions hearings. As far as the issue of, for example, when we were looking at State's Exhibit 4 and the potential for the audio portions of that, and Your Honor ruled that those audio portions, the state was arguing that those were not offered for the hearsay purpose. We were saying that we're not hearsay. They were going to defendant Lewis's mental state of whether he had a conscious disregard for unknown risk. And, you know, Your Honor said, look, we're not going to let you do that. If anything, Your Honor then looked at this and considered kind of a 403 balancing test, and whether we agree or not on whether those statements should be admitted to prove that he knew of the risk and then consciously disregarded it, because state's position is Oregon law does support that. It doesn't matter, because Your Honor also did that balancing test. Saying,
I should make that record clear. Yeah. I certainly inquired with Mr. Hughey as to the hearsay part. I ultimately determined that the state was correct. It would not come in here as hearsay for that purpose. That is a purpose that is correct, authorized under Oregon law. But then, having engaged in the 403 balancing test, I excluded it as being having the undue prejudice substantially outweighing whatever probative value. I just want to make that clear.
Correct, Judge. And thank you for making that clear. I think what I was getting at was just the idea, like when I consider, for example, the manslaughter case law around there, when the state goes into someone who's got a DUI conviction and gone through a victim's impact panel 3 or 4 years prior, maybe 2 different ones, and then we would offer that to prove that someone was acting recklessness years later when they got drunk again and drove again. And Oregon case law is pretty clear that that's permissible. Maybe it'll change in the future, but so far it's still on the books as far as what's allowable and what's not. So in the state's position, we were kind of looking at it in a similar way, but instead of years between, we're looking at 10 or 20 minutes. Regardless, that balancing test really goes to the merits of any motion to sever, because by engaging in that balancing test and deciding that if there was anything prejudicial there, where we have 3 different co-defendants, one of whom is kind of acting in and apart, and then suddenly they're all in concert. Later on, everyone's together for a large portion of this case, but there is a segment in the beginning where they aren't. So by looking at that, engaging in that balancing test, and making the rulings Your Honor made, so that as far as States Exhibits 4 and 5, I think you've really preemptively addressed any motion and the merits of any motion to sever from Mr. Lewis or from any of the other co-defendants in that part, because now we're left with 3 co-defendants, overlapping evidence, the same charges, very little risk of the jury getting confused that we can't, cure with limiting instructions to say you cannot decide that this person's guilty because that person's guilty, which comes up in any case and would be there regardless of whether there was the cases were tried together or not. So there's really very little judicial economy in doing it. There's very little risk of the jury kind of getting it wrong based on the evidence being presented. And there's so much overlapping evidence with these 3 defendants, it would not make sense to sever these cases.
Thank you, Mr. Kalbaugh. Any final words, Mr. Doyle?
I would just reiterate my motion to sever that this particular piece ties my client in a way that it would never be tied in otherwise. And by letting this exhibit in, which I still think is cumulative and prejudicial and everything, and that I think is based upon the court's rulings, I would reiterate my motion to sever.
Thank you, Mr. Doyle. The motion to sever is denied. To the extent that Mr. Lewis is prejudiced wrongfully by this evidence, it's because of my ruling on the merits of whether this is admissible or not in Mr. Lewis's case, having decided that getting rid of the things I said are not admissible, that what's left is admissible. That would be admissible against Mr. Lewis, whether or not Mr. Lewis is being tried with anyone else. If I've made a mistake there, and if ultimately Mr. Lewis is convicted at trial, the Court of Appeals is available to cure that evidentiary mistake, which again, I don't see is related to whether or not Mr. Lewis is being tried with anyone else. It's the mistake that I allowed that evidence in against Mr. Lewis, which would be true even if he were being tried alone. For that reason, Mr. Lewis's motion to sever is denied. Understanding that I need to look at Exhibit 5, and I think I actually need more than Exhibit 5. I don't know what the exhibit numbers are, but I think I need the other video exhibits that the state intends to admit and play for the jury so that I can evaluate the cumulative objection, not in a vacuum, but in combination with the things to which it would be cumulative. I'll ask the state to submit all of that to me. I will look at it. I will give you a ruling as soon as I can as to Mr. Doyle's objection as motion or objection to the admission of Exhibit 5 on cumulative grounds.
Yes, Your Honor, and I will present those exhibits on a thumb drive to the court. It'll be States Exhibits 1 through 6. I'll make a copy for everyone else, so we all have the same thing. That's usually the easiest way to do it.
Perfect.
And I will also, since we're talking about States Exhibits 1 through 6, and I think I saw Your Honor's eyebrow raised as we've been talking 1 through 5, Mr. Doyle, sorry, not Mr. Doyle, Mr. Buchal, provided an exhibit that, as I had asked earlier, we had said, hey, if there's other video that folks want, let's try to agree on which versions, and Mr. Buchal had a version. So previously, my original exhibit list was States Exhibits 1 through 7. We then conceded that States Exhibits 6 and 7 would simply be stricken, and we limited it to 5. We've now added a new States Exhibit 6, which is the video that I received from Mr. Buchal today, and all the parties should have a copy. I was in the process of helping Mr. Schmonzies load one onto his laptop as Your Honor took the bench. So my understanding is everyone has that one, and that's why you now see 6 exhibits instead of just 5, and I will forward an amended exhibit list that reflects that.
Thank you. Can I get a copy of that thumb drive by the time we're done today?
Definitely.
Okay, thank you.
I might have to run to my office to get one, but before the end of the day, you'll have one in your hand. Yes.
Okay, thank you. Mr. Lee.
Your Honor, thank you. As it relates to that thumb drive and to those exhibits, are they going to be trimmed before they put on the thumb drive? Mr. Hughey and I were talking about Exhibit 3 would be cropped. Or does that still need to be done? before-
Exhibits that are presented to the jury will certainly be trimmed in accordance with the court's order. But since the court was asking me to give them a copy before the end of the day, I don't have time to trim them.
That's
And I
fine.
didn't want to give the judge something I didn't give everybody.
I will
So-
simply disregard those portions of the videos that I've already excluded. And again, I'm not going to any merits decision here. It is merely to resolve Mr. Doyle's cumulative objection.
The primary reason I was asking was for preparation of those exhibits for opening.
Okay. Thank you.
And Mr. Doyle's objection, at least in the first, it says something about who presented. I want that on there. I don't want that taken off.
I think it's there.
Mr. Doyle brought that up when I was playing it. He's looking at a different version. When I played it on the screen in the courtroom, I started at 000 and there was no header there or anything else. So,
Well, when I saw you starting it, I saw it up there and then it went away.
Might have been a different video.
I don't know.
I know what he's talking about.
Oh, okay.
What Mr. Doyle, I believe, is talking about is that some of the videos sometimes, because of the way Microsoft operates, when you press play the first time, the file name displays as an overlay. That is not metadata that is encoded into the image. It's just so you just change that to exhibit number whatever, and that's all.
And I can just put on the record before the court, any exhibit the state offers that it intends to go back to the jury will not have the names of the file names. It'll be exhibit 1, exhibit 2, exhibit 3. The names are just as a courtesy for counsel, so you know what we're talking about.
Very well. Okay. I appreciate getting that material from the state. I will review the material as quickly as I can tonight, possibly into tomorrow, and I will send the parties an email letting you all know how I'm going to resolve Mr. Doyle's objection to Exhibit 5, and then I'll make a record when we come back on Monday, but I'll give you a heads up as soon as I can so that nobody is in confusion. Okay,
We ready for jury instructions, or do we have more motion?
that was my question.
Yeah.
Mr. Buchal, can I get a copy of that? Nah. Could I get a copy of that?
Let's go off the record for just a moment, folks, while we get our heads on straight.
Okay, we're gonna go ahead and go off the record and we're
You know, I really didn't think we'd be off the record this long. Looks like most of the other news agencies have dropped out. Coin is still here, and that's just basically them and me. Yeah, at this point there's only one, one video, one browser, multiple browsers, but that's probably not overly helpful. Apparently my background video is actually, when I bought it, it was for 4K. So it's very high res. Oh no, I'm talking about the video background that's playing right now. The starting screen is just a single video file. The stinger causes problems. And I might get rid of the stinger. Even though it looks pretty, but Now, right now, the biggest issue I'm having is still encoding lag, and I'm not entirely sure why. No network issues, a little bit of render lag. I probably, when I downscaled stuff over lunch, I probably didn't tweak the encoder correctly. I really would be surprised if it did that, but
The jury, and we will take on, or we will now take up jury instructions. The clerk has prepared a compendium that includes everyone's proposed instructions and identifies when, if a party is, or if a particular instruction is jointly requested, if it's requested by less than everyone, who is doing the requesting, and if it is being requested in different forms, who is requesting what form. So we're just going to march through. The set of jury instructions does not include the introductory instructions, which I gave over partly a couple of Fridays ago, and then again this last Monday, Tuesday, and Wednesday to each of the individual panels. That will be the first portion of the instructions. We'll then proceed to precautionary instructions, which are jointly requested by the state and Mr. Schultz. Does anyone object to the precautionary instructions? No.
No prediction.
Okay.
And, I'm just wondering why 5 has an asterisk by it. Am I?
That will be removed. The way I actually give the instructions is I do instructions before I do closing arguments, so 5 and 6 will be reversed. That asterisk comes from the uniform form and notes. Some judges like to give instructions first, which I do with a couple of exceptions I'll tell you. So the precautionary instructions will be given as listed without the asterisk and with 6 coming before 5. But renumbered. Okay. Without understanding, there's no objection. That will be the form of this instruction. Page 7 of your compendium is a request from Mr. Schultz and the state seeking Uniform Criminal Jury Instruction number 1006 relating to evaluating witness testimony. As requested, it seeks the uniform form of that instruction without paragraph 6 on the understanding that there are no previous convictions that are likely to be introduced. The question is always whether paragraph 5 is appropriate, and it depends on the evidence that it comes out in trial. My usual practice is to not include 5 unless and until we get to the end of evidence and somebody asks for it to be put back in. Is there any objection to so proceeding?
None from state.
I wouldn't accept to that.
You would not accept to that. Okay.
No objection, Your Honor.
Thank you.
Well,
5 will be removed for now to be put back in if anyone wants it. Mr. Doyle.
evidence concerning the character of the witness for truthfulness. I was thinking that it kind of really relates to some of the witnesses, and I don't know, do we have to do it each time we think a witness is prevaricating? Can we just have 5 in and just leave it in?
I will give 5 to the extent that the evidentiary record supports giving 5. Before we have heard witness testimony, I don't know whether there will be any evidence concerning truthfulness. Evidence concerning the character of the witness for truthfulness. Often evidence comes in that suggests this witness may or may not be telling the truth. It is much rarer that the evidence comes in as character evidence. So again, if such character evidence is presented, any party may request that I give 5, but in the absence of such evidence, I will not give 5.
Can we also request 6 too? I know there's
Certainly.
a line.
If the evidentiary record supports, certainly. Okay, so 5 and 6 are out for now, but I'm open to any party seeking that they be put back in light of the evidentiary record developed at trial. The next proposed instruction is uniform criminal jury instruction 1006A, requested both by Mr. Gibson and by Mr. Schultz. Let me check with the state first to see if there's any objection to 1006A.
This is, the state's position is this is much like what we were just talking about with evaluating witness testimony. If it's appropriate, then we would ask it to be given, but as a blanket offer, we'd ask not.
Okay.
We won't know yet. I mean, anytime you have police officers testifying, you run that risk of a vouching statement coming out.
Okay.
If, when we complete the evidence, that never popped up, I won't accept it. It's not given.
Fair enough. I'm going to keep it in the compendium for now, more as a trigger to make sure we remember to talk about it than anything else. But I agree, 1006A should be given if the record supports that, should not be given if the record does not.
May I interject at this point as
you may?
As we finish 1006A, the state had a late submission for 1006B after we chopped up all those videos. And that's just the pattern instruction related to not making inferences about redactions.
Very well. Can you read, just everyone may not have a copy, would you read that instruction aloud as the clerk displays it?
Yes, it is 1006B. It says, during the trial, the court may receive or have received evidence in a modified form. This evidence may have been edited because it contained irrelevant or otherwise inadmissible material. If you notice or suspect that evidence has been modified, you are not to speculate about the substance of what may have been removed or modified or why it was modified. You should not consider evidence to be of greater or lesser evidentiary value based solely on the fact that it has been modified.
No exception.
No exception.
I'm just reading the note with it, under it, and
Sure.
I can't read that quick. Is that where are we?
This is the instruction as proposed by by the state, and it is the uniform 1006B instruction.
So comment CRS.
The comment will not be included, it's just.
No, I'm trying to read it
Okay,
because
stop.
I'm trying to figure out whether I want to take an exception or not.
Understood.
I'm going to be ornery and I'm going to take an exception to that based on the comment.
Very well. 1006B will be given over Mr. Lewis's objection in the uniform form of the instruction as to modified evidence. The next proposed instruction is uniform instruction 1008. This has been requested by Mr. Schultz and by the state, both relating to inferences. So anyone object to the?
I didn't mean to request it, but I don't have any lawful basis to object to it, even though I don't like it.
We object to it as unnecessary.
Very well.
And that's 1008 that we're talking about.
Yes, inferences. The uniform instruction.
Okay, I have no.
Mr. Doyle, as to the proposed instruction on inferences?
He had no objection, he said.
I'm sorry, I did not hear that.
I have no objection, Your Honor.
1008 will be given over Mr. Gibson's objection. It is a correct statement of the law. I believe it will be useful to the jury in making the decisions the jury has to make in this case, and will not engender confusion or otherwise interfere with the jury performing its assigned task. Next is are various versions of uniform instruction 1009 relating to innocence of defendant proof beyond a reasonable doubt. Mr. Gibson?
We should defer to Mr. Schultz because we'd like him to take the lead on this, and we do not anticipate objecting to what he finally works out.
Very well. Mr. Schmantzes, on behalf of Mr. Schultz, has offered two different options.
I like option A, which is the civil instruction, although Mr. Buchal was pointing out to me over the break that there's some reference to, in number 9 on page 10, line 9, page 10, a reference to, I mentioned at the beginning of the trial that in civil cases for damages, the burden of proof is preponderance. That's not in the uniform criminal precautionary instructions. So that's,
So I did at the beginning of my presentation to the jury.
Oh,
That's
all right,
what I
great.
wanted to know.
What I told the jury is, I should have sent you a copy of this, but here's what I told the jury. Some of you may have served as jurors in civil cases where lesser standards of proof apply. For example, proof by preponderance of the evidence or proof by clear and convincing evidence. In criminal cases, however, the state's proof must be more convincing. It must be beyond a reasonable doubt.
And then this instruction is coherent with that and in line with that. So I am asking for the civil instruction to be read. Judge Norby, for what it's worth, in Clackamas County, this is the instruction she gives. I think it's purely your discretion. I don't think the state objects, but that's what we're asking for.
We join with him.
Thank you both.
Of course.
Option A for all defendants, state take a position.
I do, Your Honor. The state objects to option A, and here's why. It's the line 4 on page 10. Line 4 discusses whether, after careful and impartial consideration of all the evidence in the case, it leaves you convinced to a moral certainty that the defendant is guilty. I personally have run into trouble trying cases with that exact phrase where it has derailed more than one jury, and I can give the context for it if it helps. In one situation, I believe Judge Buchal was the judge presiding over the trial, and it was some sort of a felony doing, someone got injured, and it didn't seem like this was going to end up being a huge issue, but it just happened that at the time in the newspapers, there was a lot going on with people who were gay being able to be married, and somehow the moral certainty of gay marriage ended up overtaking the entire panel, and everyone got sideswiped on morals and morality in that issue, where it just became very difficult for the prosecutor and myself to try the case. I was a defense lawyer at the time. It was really, really strange. I didn't expect it to happen, but that language, moral certainty, can mean different things to different people. And because of that, I do think it has a potential to confuse jurors, especially if there are some jurors on the panel who may have one idea of what's morally right and some that may have a different idea, and some who may feel that triggers some sort of a religious overtone, which was something that was discussed in voir dire, and some people had strong reactions to it. So I find it safer to stay away from the language about moral certainty. I understand it. I think it's a correct statement of the law, but as far as the chance of whether that specific instruction works, I don't think it does.
Thank you, Mr. Kalbaugh. That objection is closely reasoned, well articulated, and well sourced, and I appreciate it. I am also going to overrule it. To begin with, I gave the moral certainty language at the beginning of the case, which is nobody's fault. I did it, and the reason I did it is because I think it is more helpful than not. It is very interesting, and I'm going to spend some time thinking about the historical example that you've pointed out, because that's the first time that sort of thing has been pointed out to me.
But that's when he was a defense attorney. Come on.
The reason that I like
it worked out well for me in that situation as a defense lawyer.
Sure. The reason that I like the moral certainty language, I agree it's a correct statement of the law. What it also does is it takes this instruction out of the realm of being circular. In the absence of that language, the jury is left with an instruction that tells it that reasonable doubt is beyond a reasonable doubt means proof beyond a reasonable doubt, which offers no guidance to the jury at all. I am aware of, and I'm more aware of than I was 3 minutes ago now, that moral certainty may not be impregnable and that it may cause its own issue, but I think it is more useful than it is risky, because it gives the jury something to anchor the standard to. For that reason, because I believe that was the state's only objection to option A.
Well, the state's, that was my only objection. I would just urge the court to consider option B for the reasons that I already stated in my objection.
Thank you.
And I don't think option B is as circular as the uniform instruction is. And as a member of the jury instructions committee, I will work with them to try to fix that.
Thank you for taking that note. I'll have another note for you coming up shortly to take back to that committee. Yeah, firmly convinced versus moral certainty. I see. I take the point from the state. We're going to rely on. We're going to use option A. Moral certainty has worked well in my experience, and I trust that it will work again. Mr. Schultz and Mr. Gibson have each requested uniform jury instruction 1021 relating to defendant not testifying. They requested it in slightly different forms, I think relating to, I think the difference is the third paragraph offered by Mr. Gibson, which I think is intended to address an issue with a multiple defendant case.
And I'll join in Mr. Gibson's instruction if the court's willing to give it.
Thank you.
Me too.
Thank you.
It's an accurate statement of the law, Judge. We have no objections.
It is an accurate
It is,
statement of
correct.
the law. I agree. And 1021 then will be given in the modified form requested by Mr. Gibson, understanding no other party objects. I agree it's a correct statement of the law, and I believe it would be helpful to the jury. And of course, the defendants are entitled to the instruction. Next is a joint request from the state and Mr. Schultz relating to Uniform Criminal Jury Instruction 1024 relating to defendants' statements. This appears to be offered in its uniform form. Does any other defendant object?
We have a modified version of it that adds something at the end.
I'm sorry. Thank you, Mr. Buchal. Mr. Gibson has requested a modified version of 1024, which begins on page 13 of your compendium. And the
How are they different?
I don't see the difference.
Oh, I'm sorry, wait a minute.
They
You told me they were different and I believed you. If they're the same, they're the
I think
same.
they're the same.
Sorry, never mind.
We'll withdraw ours and join theirs.
I think the minor difference is sub 1 reads express what he intended to say, and the modified one says express what that defendant intended to say.
Yeah, I don't see it.
That's the only difference I can perceive.
Okay.
Form over substance.
Uniform form will do for Mr. Gibson. 1024 will be given in its uniform form, assuming no objection from Mr. Doyle.
No objection.
That instruction will be given as requested and is not objected to. Next is the state's request for Uniform Criminal Jury Instruction 1025 relating to direct and circumstantial evidence.
They're allowed, it's the correct statement of law, so.
No objection
No
from Mr.
exception.
Schultz. Mr.
We
Buchal.
don't understand why circumstantial evidence is a focal issue in the trial. The comments on this instruction say that it should only be given when circumstantial evidence is a focal issue in the trial. We think that there's direct evidence of what they did at Cider Riot that day. The jury can look at that, see that it's, and we don't want them pushed off into some realm of circumstantial evidence when it's not called for by the circumstances of this case.
Would you hear the argument?
Particularly given the political context.
Oh yeah. I don't think we agree. Components and elements are probably heavily rely on direct evidence, but I think other elements rely on circumstantial evidence, namely the mental state. And we would argue that this is still correct and should be given.
I agree with the state that this instruction is, in my view, is rendered appropriate because of the mental state that the state is required to prove beyond a reasonable doubt. This is not a case where anybody says explicitly, this is my mental state. And so the jury is going to have to rely on circumstantial evidence for that purpose.
I would join in.
In the objection.
Yes.
I was about to ask. Thank you. So 1025 will be given as requested by the state and over the objection of Mr. Gibson and of Mr. Lewis. Top of page 15 is Mr. Lewis's request for uniform criminal jury instruction 1030. Is there an objection from the state?
Yes, Your Honor.
Thank you. Let me hear the argument in favor of the instruction, and then I'll hear the objection.
Well, because of all the inferences, the different films, and just because of the some of the instructions that have already been given over my objection and some of the evidence that is going to come in, I think that there is very definitely some possibility that the state can produce better evidence than it's going to produce.
Do you have a particular piece of better evidence in mind that the state should have but has not produced?
I think that it is, well, when they talk about mental state and what they're trying to do, I think that I think that once the evidence is in, that there could obviously be better ways of proving mental state than.
Okay. Thank you, Mr. Doyle.
Especially when I still think the number that the court is counting is going to be possibly some of our people and possibly some of the Cider Riot people, because that.
So to be clear, I've not ruled on that yet. I've not ruled on the issue yet. I think it is about to become due.
But that would be
okay.
One of the things is, why are the Cider Riot people involved in doing stuff?
Thank you. Does any other defendant wish to be heard on this proposed instruction? Mr. Buchal.
There is a lot of less satisfactory evidence. There is a lot of more satisfactory evidence that could have been obtained and presented. I mean, it's essentially the state's theory that there's some sort of coordinated attack by an organized group led by Mr. Gibson. In this day and age, they have the ability to prove organization through various electronic communications and contacts which don't really exist. And so they are attempting to present this image of the organization and not presenting proof that it happened.
They did not. Sorry, I think your argument just turned on itself. The instruction advises the jury that if the state could have gathered stronger and more satisfactory evidence than it did, that the jury is empowered to, and in fact instructed, to view the weaker and less satisfactory evidence with distrust. I think your point is there is no other evidence. So it's not that it's weak, it is weaker than evidence that does exist. It is weak because no other such evidence exists. I think those are two different things.
Yes, the way I interpret the instruction, it's that if there are pieces of, like, for example, the security cameras at Cider Riot, we asked them to get them, and they didn't, and so that would have been good evidence. In that particular case, we asked for it. But other evidence, for example, we see people holding phones and talking. We see. Now, this evidence isn't in yet, so maybe.
Understand.
But it's that kind of thing.
Okay.
Factually, in case the court wasn't aware, there are security cameras internally and externally at Cider Riot that would have provided a steady view of the entire thing, not a camera that's moving around.
Okay, thank you. Does the state wish to be heard?
Your Honor, it would be inappropriate to give this instruction based on the arguments that are being made, based on the commentary as far as when the instruction is suggested. It should be appropriate. And here, by giving this instruction, especially in light of the fact that we just argued numerous motions and discussed how to limit how to edit the video and such, it would just lead the jury to believe that something was wrong with the video they're being presented with, let alone anything else. So this is completely inappropriate to give this instruction.
So,
Your Honor, I have one more argument.
Mr. Doyle.
Their argument.
Go ahead.
No, they're not done.
I believe he was done.
I was only going to ask if it looks like we're the same as the modified 1030 by Gibson. I don't see the modification, so I think we're arguing both at once. Okay,
thank you. Mr. Doyle.
I was just going to say that some of the evidence concerning the character of the witness for truthfulness, that I think some of the state may or may not be rehabilitating their witnesses. I think there's a problem with some of the. it is our view that at least one of the videos was shot with someone, was shot by someone that had a prejudice.
And that person will be here and available for cross-examination.
And
So I'm sorry, is the argument that to the extent other videos not shot by such a person may have been available, those should have been produced rather than?
yes, Your Honor.
Okay. I didn't mean to cut you off, but it suddenly, the light bulb went off for me. Okay, I'm going to defer on this instruction. I need to see what the evidentiary record is. And we can briefly argue it before instructions are given at the close of evidence. That's going to bring us to page 16. Mr. Gibson and the state have each requested uniform criminal jury instruction 1035 relating to intentionally with intent, which I understand is coming from ORS 166015's intentionally standard. Mr. Schultz has requested 1036 relating to knowingly and with knowledge, but I don't know where that's coming from.
That was pled, Judge. So when it's pled, I think that's controlled.
And is that because if a person acts recklessly, they act, well, no,
There's
that doesn't
recklessly
work.
in there as well. I mean, I think you still need to give intentionally because you can prove reckless conduct by intentional.
Oh, I'm sorry, I'm so sorry, yes. The knowingly goes to the knowingly engage in tumultuous and violent conduct. And then.
As well as knowingly with 5 people.
Right. Knowingly with 5 people, knowingly engaging in the conduct, and then intentionally.
Doesn't apply to grave risk of public inconvenience. Knowingly has nothing to do with that.
Okay.
Different element.
Right.
It's all Simon knows that.
They should be instructed on all mental states, because if any mental state is satisfied, recklessness is satisfied. So I think every mental state should be in the instruction.
Did you offer a if reckless then knowing? Or if knowing then reckless, I should say. Is that in here?
It should be part of the reckless, isn't it?
Okay.
It should be at
Intentional
it's at
than
the
knowing.
end of reckless.
Yeah.
But Mr. Schmumpsy has answered my actual question, which is where does knowing come in explicitly, and where it comes in explicitly is as to with 5 people and engage in in tumultuous and violent.
Yep.
Okay. Is there, in that case, I will just walk through these. Is there any objection from any party with respect to 1035 regarding intentionally and with intent?
No.
It is a correct statement of the
Correct.
law. It is necessary. It will be given
Yeah, that's right.
without objection. Is there any objection to Uniform Instruction 1036? I see. Okay, now we have competing versions of 1036. I think we're all agreed we need some version of 1036. Mr. Gibson has offered a modified version. Mr. Schultz has offered the uniform version of Uniform Instruction 1036 relating to knowingly
I
and
agree.
with knowledge.
I prefer Mr. Gibson's.
Very well.
I think they say the same thing. I think theirs is a little more, it spells it out and it is a little more clear.
Okay, I understand that Mr. Schultz is withdrawing his version of
Yes.
1036 and is joining with Mr. Gibson and Mr. Gibson's requested version of 1036.
Yes, Your Honor.
And Your Honor, the state's asking for the proposed uniform instruction from originally proposed by Mr. Schultz. I get that he's moving away from that, so we'd be adopting it. But the reason we're asking for that is it's confusing to instruct the jury on the mental state of knowingly, and while doing so, interject all other mental states in the description of what it is. So that's why we like the uniform instruction. It's more to the point and it's shorter and it's in the context of Your Honor reading the jury the different instructions. And when 14 jurors are listening to Your Honor read them, the state's concern is that they will be confused when they hear you instruct on knowingly by cross-referencing every other jury instruction. Mental state, sorry.
I take that concern seriously. I think the way to fix that may be in Mr. Gibson's 3rd paragraph to excise in the 2nd line reading onto the 3rd line, thereby intentionally and recklessly creating a grave risk of causing public alarm. So that if you remove that, it reads, when used in the phrase that unlawfully and knowingly while participating with 5 or more other persons engage in tumultuous and violent conduct, knowingly also means that the person acted, etc.
I agree. Yeah. That makes it much more clear.
What's this one, Drew? Same thing?
Yeah, and same thing in line 6 and 7.
I'm all confused.
I thought you were just reading 6 and 7.
No, look,
It's in line.
Sorry, I was doing 6 and 7, but
Oh.
it should be in, it should be in the above paragraph
2 and
2.
3
So,
and 6.
2, 3, and 6 and 7.
so that the first paragraph on page 17 should read, when used in the phrase did unlawfully and knowingly, while participating with 5 or more other persons, engage in tumultuous and violent conduct, and then the quote should end there. And then it should read, quote unquote, knowingly means that the person acted with an awareness that his or her conduct was tumultuous and violent.
That cures the state's concern.
same excision in line 6 and 7.
And then, so I'll just read the second paragraph with when used in the phrase did unlawfully and knowingly while participating with 5 or more other persons, engage in tumultuous and violent conduct, quote ends there. Quote unquote knowingly, with a comma inside the quote, quote unquote knowingly also means that the person acted with an awareness that he or she was participating with 5 or more persons who were also personally engaged in tumultuous and violent conduct.
Yes.
Yes.
Any objection to that version of that instruction?
No.
Okay. 1036 will be given in the form requested by Mr. Gibson with the court's edits as stated on the record. Next is Mr. Gibson, Mr. Schultz, and Mr. State, and the state's joint request for uniform criminal jury instruction 1037 relating to recklessly.
Recklessly. Yeah.
Does anyone want the bracketed language?
Might as well leave it in there.
Okay, so we will leave the bracketed language in, but without the actual brackets.
Right.
Can we add, I'm sorry, that's a little confusing. Can we say if the person acts intentionally with regard to the risk?
I think that will engender confusion.
You can probably just argue that. Right?
And shouldn't that read recklessness is also established if a person acts intentionally or knowingly? Yeah,
That would also be a correct statement of the law.
Ask it to read that.
Any objection to that?
It's not a hill I'm interested in dying on, so go ahead.
Okay.
My only objection, Your Honor, is that if you view that sentence in splendid isolation, people may be regarded as always acting intentionally or knowingly, and it is disconnected from the subject matter of the risk.
Well, well, here's what's a little odd about this, actually, since we are here. This statute is written, I am unaware of any other statute, maybe somebody else knows, where the two ways the defendant may violate the particular term of the statute is intentionally or recklessly with no other standard identified. That's a little odd. In this case, if the jury finds that a defendant acted intentionally and otherwise violated the statute on the other mental states to the other elements of the statute, the jury has answered the question. That is to say, the only place where reckless matters is creates a grave risk of causing public alarm. But the other way that a defendant may satisfy that element of the crime is by doing the same thing intentionally.
Right.
So what are we adding?
I'd rather not have it at all.
I think we're adding the clarification, as ridiculous as this sounds, jurors do things like this, where the jury says, I don't think they were disregarding a risk. I think they knew this was going to create public alarm, but apparently we can't find them guilty for that.
That's handled on line 9 through 11 of page 16.
Well, no.
That's not.
Oh, because Mr. Hughey went to knowing, not intentional. That's okay. We don't really need recklessness is also established if a person acts intentionally. The state doesn't need that, because if the state proves intentionally, the state has the jury has already found that the defendant has committed that element of the crime.
Let's take it out then.
Let's
Well,
take
we'd
it
like-
out.
What the state is asking for, I think,
Oh, no.
is recklessness is also established if a person acts knowingly.
Yeah.
We want to know.
No? Yes?
Yeah, I think we'd like both, but I understand that intentionally is going to be in the element.
It's going to be awfully confusing to
Yeah.
tell that jury, you can find if you find that the state proved beyond a reasonable doubt that a defendant acted intentionally or recklessly, the state has established that element of the crime. And also, by the way, you can find recklessness if you find intentionality, even though intentionally is the, right?
Yeah, let's just cut it.
Is
Well, except the state is entitled, the state is suggesting it's entitled, and I'm inclined to agree, it's entitled to have the jury consider whether any defendant acted knowingly. Because if you act knowingly, you have acted recklessly, right? Because it's the greater mental state.
Yeah. I know it seems weird, but juries do reach that kind of conclusion, which would satisfy that element. And if they didn't understand that knowing satisfies reckless, they would wrongly think that they hadn't found that element when they had.
Well, then we can take out knowingly and with knowledge and take all those out and leave in reckless, or we can take out reckless and leave the others, because I just.
If the statute were written a little more, with a little more care, I would agree with you, Mr. Doyle. The problem is that the statute requires, on the one hand, knowingly as to tumultuous and intentional or knowingly as to tumultuous and violent, or intentionally or recklessly with respect to creates a grave risk of creating public alarm.
Maybe,
I got a solution. My solution,
Mr. Rico first, then Mr. Hughes.
line 20, when used in the phrase intentionally or recklessly created a grave risk of causing alarm, recklessly means that the person is aware of and consciously disregards, and then in parentheses, or actually knows there is a substantial and unjustifiable risk.
I think we should table this, finalize the elements of riot that we're going to instruct them on, and then come back to it once we know how the elements read.
Okay. All right.
Which is only a couple pages away.
We'll reserve on 1037.
Don't you think?
Just gonna delay it.
On page 18 is Mr. Gibson's request for uniform criminal jury instruction 1047 related to public place.
I also request it.
This is out of order, Your Honor, in that it meshes with a bunch of free speech instructions.
Okay. I understand 47 is jointly requested by Mr. Gibson and Mr. Schultz. We'll reserve and come back when we are in the free speech section of the proposed instructions.
And I'll be in that.
And as well as Mr. Lewis. Mr. Schultz has requested uniform criminal jury instruction 1059 relating to separate consideration for each defendant. Is there any objection?
No.
Mr. Gibson has asked it for a modified form.
Yeah, I've asked for an additional sentence at the end, which appears on the top of page 19. Because of the complexity, it's not just that you consider the evidence for each defendant, but that you walk through the evidence and the elements separately. Because we're very concerned that it's sort of one riot, everyone's guilty, and they're not going to focus on the elements separately.
I'm a little lost as to what that sentence does that the second sentence of the instruction doesn't do.
It adds the word elements. It focuses on the elements of the crime.
The evidence for against. Okay.
I think it's confusing. I'd ask the court not to give the.
I agree. I think, while I understand the word elements doesn't appear in the earlier part of the instruction, I think it is repeating things using slightly different language, which is likely to to trip up the jury. I think 1059 includes that by saying that you must consider what the evidence shows as to each defendant. And then, of course, I think the jury will understand it needs to apply the evidence to the elements as to each defendant. So 1059 is going to be given in the form requested by Mr. Schultz without the objection of the state, over the objection of Mr. Gibson, and I'm happy to let Mr. Lewis state a position.
All right.
Whether you'd like to join Mr. Gibson's version, join Mr. Schultz's version, or object to the instruction in its entirety.
I will join in both and object to the instruction.
Very well.
That's why I have the motion to sever. So
It will be given
try to be consistent.
over Mr. Lewis's objection as well. Okay, we're now getting into the particular definitions relating to the riot charge. The next proposed instruction is Uniform Criminal Jury Instruction 2306. The state has requested the uniform form relating to the definition of violent, tumultuous, or threatening behavior. Mr. Gibson has requested a different locution, which is in the compendium, so I won't read it out loud.
Yeah, but it's a uniform instruction.
We don't believe that the word threatening is appropriately in the instruction at all, Your Honor, and it vastly expands the concept beyond what was intended in Shakarian and the other cases.
Let's take that issue up first. Does the state believe or threatening should be in the instruction?
Words are not physical conduct. Okay. Right? Do we need to define, sorry, Judge, I'm getting a little ahead of myself, but.
Let me urge you not to. Let's deal with this, and then I think I know where you're going. Let's take that up immediately afterwards.
Okay.
I think we can strike the word threatening, Your Honor. I think that language is coming directly from the Cantwell case, which is listed as authority. The 1984 case, I believe it was the same version, but I also don't see a problem in.
The difference is.
Oh, that was disorderly conduct. That was
right. That's the that
So we
is
can
the problem with this instruction is right.
We can strike the threatening word from there. Otherwise, it is the same.
Okay, I agree that the words or threatening should be removed, and those are ordered removed.
May we change behavior to conduct as well?
Is there any authority for that?
Matches the well, so that it matches what you're trying to define one of the elements.
Yeah, I don't.
And you've changed one of the words for no apparent reason.
It's a reasonable point. I'm mindful of the Court of Appeals' admonition that just because a word appears in a Court of Appeals decision does not make it properly meet for a jury instruction. In this case, I agree that I'm looking at the Cantwell case now. It uses the word threatening, but again, it uses the word behavior, but again, that's in a disorderly conduct context where it is not crazy that a court would use a word other than conduct in defining disorderly conduct. So as to avoid some circularity. So I think I'm with Mr. Gibson.
Fine.
Okay, understanding the state does not object. So violent or it should be, and also I believe it has to be because of the way the statute is written. It can't be the disjunctive. I think it has to be the conjunctive. Does it not?
Yes. Correct. Correct. Violent and, yeah.
Certainly, that's how it's charged in the indictment, and that's how it appears in ORS 166015. Person engages in tumultuous and violent conduct.
Yeah, I think
Correct.
the ORS controls, not the indictment, because it's pled in the conjunctive, but.
Which means you could drop down. Yeah. Well, no, you could go the other way. You couldn't go
disjunctive, maybe.
Right. You could not go from
But because it's in the statute, I think we're
Okay.
Can I just confirm that? So it's violent and tumultuous conduct, and then which?
So So definitions 6.
Yes.
Violent and tumultuous conduct.
Correct.
And then we are now picking up the issue that you are
Okay.
raising.
2306.
It's almost like a circular.
What's the green?
So,
Just a highlighted, just where my cursor was.
so the state is relying on the uniform form, which cites to ORS 1660251A, which is the disorderly conduct statute, and relies on State versus Cantwell, which is a disorderly conduct case.
Correct, riot being disorderly conduct, essentially with additional people.
Okay. So
Essentially.
essentially, I guess my question is, is Cantwell the only authority the state has for the notion that physical conduct that is likely to produce the use of physical force? Or does that come from, say, Chakarian or anywhere else?
I can check, Judge. And while I'm looking, is there authority for defense's proposal?
Well, I was just pivoting, thank you.
Because the state's largest problem with that is the circular definition, which earlier was the whole issue when we were looking
That
at
violent
reasonable doubt and other
means
stuff.
acts of violence.
Yeah, it doesn't help the jury at all.
Cannot help but note that you are on your feet.
The disorderly conduct statute, as I'm sure the court is aware, punishes more behavior
Yes.
than the riot statute does. And I don't agree with Mr. Kalbaugh's assertion that riot and disorderly conduct are the same. You just add 5 people, because you can make unreasonable noise. There was the Benton County Courthouse where the defense attorney was found to be disorderly conduct just for words alone.
Right.
And our whole defense here is that words alone are not sufficient. So I don't think it.
Fair enough. I apologize for my gross.
No.
oversight.
I candidly, I understood Mr. Kalbaugh's point to include Mr. Schmancy's caveat, but now it's clear on the record. And I'll just note, so we have a clean record on this. The state is asking for an instruction that violent and tumultuous conduct is physical conduct that is immediately likely to produce the use of physical force. Mr. Gibson, and I think Mr. Schmancy's maybe joining, seeks a definition that violent and tumultuous conduct means physical acts of violence. The question is, which is right, if either, and if not, what is the correct formulation? Mr. Buchal.
The problem that we have is that this is a First Amendment case, and one of the biggest issues in the cases is whose fault is it if the Antifa people go berserk and start attacking everybody?
Well, I understand that's your view of the case.
Okay, and so what this says is if the jury concludes, without regard to anything else, that walking up to Antifa is likely to make them exert physical force, we lose, which has no protection for the First Amendment at all and is a gross violation of it. I would refer the court, instead of Cantwell, to the discussion in Shakarian.
Which is what I'm looking at as we speak. So here's what I have from Shakarian. They cite the Webster's third definition of violent. Okay. They cite the Webster's third definition of tumultuous. They then say in the following paragraph,
extreme force.
The common definition. This is Shakarian. This is the Oregon Supreme Court in 1997, and this is on page 378. Giving the statute a fair reading in the light of the common definitions of the terms of tumultuous, violent, and conduct, we conclude that the statute refers to physical activity that reasonably is perceived by others as threatening an imminent breach of the peace.
But by whom?
There you go.
By whom? It is the rioters. It is when they talk about the Webster's definition on the prior page 377, it's all about what these people are doing. And
so sorry, we may be talking past each other. Let me just try to put a sharper point on what I'm saying, and then we'll find out if we are or not.
Sure.
What I understand the Supreme Court's definition to mean is the statute refers to one, I'm doing the numbering, one, physical activity, two, that reasonably is perceived by others. I see that as having both an objective and a subjective component, that others must see that physical activity as 3, threatening an imminent breach of the peace, and that 2, and that in addition, objectively, that perception by others must be reasonable. So it has to be, we're talking about physical activity that is in fact perceived by others as threatening an imminent breach of the peace, and when those others perceive that threat of an imminent breach of the peace, that perception is itself reasonable.
All of those things are true.
What's the
And
problem?
we are talking past each other
Okay.
because I am zeroed in on the idea that what is important is the conduct of these defendants.
Right.
And so when we talk about the state's instruction with producing the use of
I
physical.
agree. I'm sorry. I beg your pardon. I am
Okay.
past the state's definition because I agree it is infirm.
Okay.
I also believe your definition is infirm. What I think is correct is the expression in Shakarian, which says exactly what it says.
I think the state has also passed its own definition and is on to the Shakarian definition.
We are.
Yeah.
I think I understand.
Physical activity reasonably perceived by others as threatening an imminent breach of the peace. That's the definition of violence.
Which means, just to be clear, because we've talked about, everybody talked about it, except maybe me during voir dire. It does suggest that if you are provocative in your physical activity, that can be enough. But it looks only to physical activity, not to speech.
The difficulty, I know Mr. Buchal is gonna, he really wants.
I'm happy to hear you both.
Thank you, Aaron. The concern is without a definition of physical activity that uses the word violence. You can imagine a scenario in this case, in a First Amendment case, which I don't think those ones work, where the argument is now available that the physical activity was Mr. Gibson walking onto the sidewalk where he had a right to be, and that's the physical activity that caused these people to respond in violence. And so when you have that in a context of a First Amendment case where he has the right to be in that location speaking,
Hard to wait your turn.
and now he's again he would then be held liable essentially for riot because of the way they reacted to his being in a place he's allowed to be by walking there, and that's the physical activity, which is not violent, and that's not what the statute is talking about.
Now, doing that, of course, would, in order to so find, the jury would also have to find that Mr. Gibson's physical activity in your, I'm going to call it a hypothetical, though I understand, that the jury would have to find that Mr. Gibson's activity caused someone to reasonably believe that Mr. Gibson was threatening an imminent breach of the peace, right? Isn't that what saves that scenario? That
Buchal is going to answer this.
And the objective standard.
And the reason it doesn't is because it doesn't give any weight to the First Amendment. Now, if you look at the case and that sentence we are proceeding, right at the end of that sentence is where the Supreme Court dropped footnote 11.
to Rudyard Kipling.
Well, to the notion that, well, we're not really thinking about what happens when this is part of free speech or something. You see, they realize that, that this conduct might occur in conjunction with expression. And that brings up this whole additional range of considerations, which is the fact, if the jury comes to the conclusion that the nature of Antifa is such that the conduct of Mr. Gibson walking up to the sidewalk would threaten a breach of the peace, we don't think he can be found guilty as a matter of state and federal constitutional law.
I hear the argument. I disagree with some of it, but at the core of it, I'm actually with you on. The answer to that, I think, is not to stray from what Shakarian teaches is the standard, but rather to find a way to instruct the jury that the only thing they consider is the activity, right? Not the actor.
That doesn't do it because walking up to the sidewalk is an activity.
I agree, right? So
it's the objective.
So There are a couple of things. Let me try this one more time, and I'm sorry to make you guys chasing me. And we may have to take 5 minutes just for everyone to get their head straight on it. But there is a thing in what you've just said that convinces me we need to do something else. But let me try to walk through the whole thing. The Chakarian standard refers to, again, or we conclude that the statute refers to physical activity that reasonably is perceived by others as threatening an imminent breach of the peace. What does that require? It requires that there be some physical activity, and I take your point that that activity, arguably in this case, according to you, is Mr. Gibson walking where he's allowed to be. That activity is reasonably perceived by others as threatening an imminent breach of the peace. There is the subjective standard that these folks believed Mr. Gibson is here, he is walking, there is about to be an imminent breach of the peace. That is a necessary condition, but it's not sufficient. There's also an objective standard, which is their belief of that must have been objectively reasonable. So it is not enough that the people who were there had an opinion of Mr. Gibson and thought, oh my goodness, Mr. Gibson in walking is threatening an imminent breach of the peace. It is also that that Mr. Gibson walking must have objectively, reasonably threatened such a breach in order for the jury to find against Mr.
Yes, Your Honor, if when you are using the word objective, are you taking the identity away from the two parties and saying a person walks up outside a bar, or are you saying, is it objectively reasonable that if this person walks up to this bar, it threatens a breach of the peace?
Very nuanced, very subtle question that I understand.
And
so I think, sorry.
We heard a lot from the panel on exactly that issue.
Okay. I think I had said a few minutes ago that it's about the action, not the actor. The question is whether that's so. Whether, so for example, hypothetically, if we have a person walk up to a bar who has a reputation for walking up to bars and then pulling out pepper spray and doing all kinds of things, as opposed to someone who does not have that reputation, does that matter with respect to the objective standard of reasonableness? Am I articulating your question back to you appropriately?
An alternative form, yes.
Okay. And I understand the thrust of your question being is the question whether an objective person seeing Mr. Gibson do this physical activity, is the question whether someone seeing, whether there's a difference between a person objectively, reasonably believing a person walking on the sidewalk might be threatening an imminent breach of the peace versus an objectively reasonable person acting reasonably, seeing Mr. Gibson walking on the sidewalk might be threatening an imminent breach of the peace.
Yeah, and I think what Your Honor is struggling for is a standard that can be applied in some sense without regard to the identity of the parties. If
well, and the question is whether or not that is required. And our position is in the First Amendment context, it is required because the difference between because the physical activity might be interpreted differently because of previous acts of speech.
Doesn't that mean we just need to define physical conduct? If we define physical conduct, we solve this problem.
I think the concern is cured by the reasonableness requirement, or the objective.
But you understand the thrust of Mr. Buchal's point, which is
reasonable in the shoes of somebody with past history or whatever. What's that?
And I'm gonna tread down a path that you can shut me up or we can take a break, is that, you know, where are we getting the 5 people from? Do any of the 5 people include Antifa? And what will the jury do?
That is a live issue in this case that we need to resolve, but it's a different issue from this one.
Okay.
But it is an issue that will be addressed and you will get a ruling on it before we begin with the jury.
Because I think a lot of this depends.
It's a live issue. I think it's a distinct issue.
Objectively reasonable that it would breach the peace, exactly.
That's not permissible.
Your Honor, I'm
So I
taking
wanna
a
go
point
back
of
to-
personal privilege, and let's take a break now.
We'll take a break in 1 minute.
Okay, thank you.
I want to engage with Mr. Schmantzes for a minute, and then I want to hear from Mr. Buchal, and then we'll take a break. Mr. Schmantzes, your suggestion is if we define physical activity to make it clear it is not speech, essentially.
Right.
Right. I think what Mr. Buchal would say back to that, although he's allowed to say it himself, is what if the identity of a person because of previous speech? What if the person is viewed as a threat because of previous speech? Does that incorporate First Amendment principles? Do we sort of bring those into the physical activity? I'm not convinced that we do, but I think that's the point.
Yeah, the point
It's
is
a
that
fair, it's a fair point. Go ahead, Mr. Buchal. Yeah, I don't have an answer to that. I think that is a problem.
yeah, in our view, he can be convicted for essentially standing on the sidewalk if a jury concludes that him standing on the sidewalk reasonably threatens a breach of the peace because he is there to protest Antifa. If you protest Antifa, they react violently. Therefore, anybody who shows up to protest Antifa, and particularly him, is a rioter. And that is not only manifestly unjust, but entirely inconsistent with the First Amendment, which doesn't let us, punish people based on what their message is.
I think one important distinction, though, is that the court has largely excluded all of that evidence from this case on the numerous motions from Mr. Gibson. There isn't going to be. The court has ruled that there is not going to be evidence of prior clashes, of their viewpoint, of name calling or things like that.
So, and I'm sorry for Mr. Doyle, 30 seconds and we'll stop. Would the state agree or disagree that the following instruction is appropriate? When evaluating, and I'm not saying it is or isn't, the question mark at the end of this is real. When evaluating whether a defendant's physical activity was reasonably perceived by others to threaten an imminent breach of the peace, you are not to consider any prior speech by that defendant, whether real or believed.
Boy. My first instinct is to say that would not be a correct state of the law.
Because if you're walking down the sidewalk saying, I'm walking down the sidewalk because I'm going to go get my gun.
And then you start reaching into your waistband or whatever as you walk towards somebody.
Right.
That goes to the reasonableness.
Right. How about as it relates to speech 5 hours before, 5 days before, 5 weeks before, reported third hand?
Well, then I think we're squarely in the factual question of reasonableness, and we're doing different closing arguments, and that's what the fact finder is for.
Okay. All right. We'll take our break. I'm sorry. I promised Mr. Buchal his turn, and then
Mr. Lee was anxious for me to point out that one of the reasons this is such a problem is because of the lack of election. But that being said, I don't think the warning about not considering prior speech works because it's about the current situation, and the jury may perceive that the current situation of him just going to protest Antifa, given the nature of who Antifa is, reasonably threatens a breach of the peace.
okay, thank you. We're going to take a no more than 5 minute break, and then we're going to come back and we're going to get on our giddy up because we need to finish this by 5.
Okay, we'll go off record and we'll mute for Webex.
this is kind of a tough one, because I see both sides on this. Because, I mean, if somebody, doesn't know anything about anybody, is just standing on a sidewalk and they see Gibson and the rest of the group coming down the sidewalk, that doesn't give rise to cause for concern. But, just, hours before, there were interactions presumably between people on both sides at ICE, at that protest and counter-protest, which would, if somebody knew just that, would give context that there's agitation between these two groups. It's like seeing your ex at the mall and walking up to her. An average person might just see two people in the mall, but if you know about the relationship and the breakup, then that's, totally different. Well, and keep in mind, for the jury, most, if not all, of the audio that you're talking about is getting stricken from the evidence. The jury won't hear that audio. And a lot of it's because the people that were making those plans, Gibson wasn't in that group, and some of them were saying that Gibson was going to be there, but the state has no evidence to link that. Which for some reason they don't have text messages, they don't have phone record, phone logs, they don't have anything, and I feel like there should have been a lot of easily obtainable information that is missing from this. Well, and yeah, okay. Let me make sure that we're on the same side about culpable. Are you talking about Gibson and the quote unquote Patriot Prayer side being culpable for their actions? While that's going, Red, it may not be that everyone at Cider Riot was at ICE, but I really expect that there were, more than a handful of people that were at both locations. And, that's just that day. It's not like Gibson hasn't been at events in Portland for at least the year before that, because, at the very least, we know the Louise thing was in 2018. So, the chances that people that have, on the quote-unquote Antifa side, have been at events with Gibson in the past and have had those interactions that cause them to be apprehensive, then he suddenly shows up and you've got people that are, carrying their flags with big sticks and wearing their helmets and stuff. I can see where, in knowing that, it can cause reasonable apprehension. And that's just looking at the evidence. Or at least what it sounds like they're talking about for what they're going to be able to say is they want the jury to act like these two groups have never met each other. They just showed up and... Okay, City Hall. I figured probably something on waterfront, but City Hall makes sense too. You know, so maybe not everybody from ICE, or, you know, maybe there isn't a connection between ICE and Cider Riot. I have no idea. You know, maybe we'll find out if one of the witnesses the state calls talks about where they were earlier in the day, if that's even allowed. But, you know, even May 1st, 2019 notwithstanding, there's other days where some of these, you know, same groups have interacted, and that's... You know, I don't need to, you know, for me, I have apprehension about cops. A normal person may look at that and say, well, you have no reason to. You know, cops are you know, they're people, they're good guys. And then when you look back and see what's happened to me because of them, that can change the tenor of the conversation, and can give context to explain why, you know, whether my apprehension is reasonable or not. It can at least explain why I'm apprehensive. That's just, you know, with everything I got going on, that's the thought that sticks right in my head. I mean, yeah, if the leftists came from ICE to Cider, then that's a huge connection, and so far it feels like the judge is not allowing that connection to be made. Which we saw similar stuff in the Swinney trial, where Judge Moad struck down a lot of Swinney's social media posts that the state wanted to use.
On the record, we're going to resolve this instruction in the next couple of minutes, and then we'll proceed to finish the rest of the instructions. I know Mr. Schmantzes wants to be heard. I'd like to start with Mr. Schmantzes, except that Mr. Doyle's on his feet.
I don't want to, I just want to show what's going on outside the courthouse right now.
I can't see it.
May I approach?
You know what? I want to save it.
Eventually?
Eventually, we will do it.
Thank you, Your Honor.
Mr. Schmantzes, as to the present discussion on the...
What we were just stuck on for 10 minutes, kind of the concerns that Mr. Buchal and I were trying to announce, is captured in lines 12, 13, and 14 that were scratched out. Specifically, we do not read the statute to encompass speech in the term behavior, but construe it to refer only to physical acts of violence, because physical conduct does not adequately protect constitutional rights of speech in a context where a demonstration can be construed as physical conduct. I mean, that's this case, right? So we need to get that language somehow, I think, into the definition.
So give me the therefore clause of that.
I really want the jury to hear that, or I want the court to enforce the rule that physical conduct does not adequately, that definition, or just the term physical conduct,
right,
does not adequately protect constitutional rights of speech in a context such as this, where a demonstration could be viewed as physical conduct. So I think what's problematic is the use of the phrase physical conduct. It's inviting the jury to convict any of the three defendants for a constitutionally protected speech. So what do we do about that? I think we may need to scrap the use of the word physical conduct.
Where is that coming from? I don't think that's actually in Cantwell.
It's right there on page 852.
Yeah, 853. 66, we're at 848, and then the page is 853.
No, I'm talking about the second sentence.
Oh, the second sentence is not in the case, right, but the second sentence on page 852 is that fighting...
Well, the question is, that last sentence is yours,
yes,
right?
Yes,
okay.
yes.
Mr. Schmantzes was citing Mr. Buchal.
Yeah,
It is a
I didn't know
paraphrase.
that. I
It is a
apologize.
paraphrase of the next sentence in Cantwell, which is fighting and violent, tumultuous, or threatening behavior describes physical acts of aggression, not speak, and in prohibiting such physical acts, the statute does not run afoul of Article 1, Section 8 of the Oregon Constitution. So Cantwell is making the point that we have to limit violent and tumultuous conduct to physical acts of violence, which was our instruction. In fact, Cantwell says we can construe it to refer only to physical acts of violence. And that's right down there on the bottom of page 852 of Cantwell. And so that's the way they.
But the of violent, but the mistake you're making there is that the part of that sentence that's doing the work on your argument is physical acts. The of violence is covered by the rest of the definition, which is threatening and imminent physical activity that is reasonably perceived by others. That's what violent. That's covering violent. Where you are getting high centered is that it has to be the physical conduct and the physical conduct only. I agree with that.
Right, and I'm saying that that's in the First Amendment context where we're trying to consider the reasonably likely to induce a breach of the speech versus physical acts of violence. Only the instruction confining the jury to the physical acts of violence avoids all the First Amendment problems, and that is why the Court of Appeals adopted it in substance in Cantwell, because they were concerned about it, whereas in Shakarian, they didn't have that context, and so they made that remark, and then they dropped a footnote, because in the footnote they realized, well, I suppose there could be some circumstances where tumultuous and violent conduct might have something to do with speech or expressive conduct, but that's not this case, and then they went off into Kipling. But the only way to square the First Amendment circle that we see is to adopt the instruction that we proposed, which tells the jury that my client had to do something violent or he's not guilty of riot. And that if the circumstances are such that he is encountering someone who's violent, that even if it's reasonably likely that because of the nature of this other person that violence would come out, that is not consistent with the First Amendment. And I know this historical example has been ridiculed when I have given it in the past, but Martin Luther King, he goes down to the South, he goes down to the white area, and violence ensues. Was it reasonably foreseeable that his mere presence on the sidewalk in Montgomery, Alabama would cause the violence?
But that I'm not really. The lesson of that hypothetical is that the jury must be instructed to focus on the act. Did the person do something? And I take your point to be, well, Martin Luther King walking down the street could set something off if there are a bunch of Klansmen standing around. But again, it is I think the solution here is that the jury is instructed that it's about the act, not the actor. That it has to be about the act itself. The example, even more preposterous, that I had in my head is you put a fox in the hen house and the fox takes a step, right? You can say, yep, that fox is threatening an imminent breach of the peace. The question, though, is I don't think you look at the fox as a fox. You don't look at the fact that there are hens in the hen house. You look at the act. Is the act itself the thing? If what Mr. Gibson did was stand on the sidewalk with his hands in his pockets, right? The fact that he is Mr. Gibson and other people have a view of him would not be sufficient, in my view, to support a conviction of riot.
The jury could find that the act of filming people causes violence. The jury could find that his narration, here's Cider Riot, they're violent communists. This is an establishment with alcohol. People of Portland, are you going to do something about it? All of walking up and down, pointing at people. If once that language about threatening breach of the peace is in there without sort of an entire paragraph of limitations.
Well,
after
but I'm sorry, this is the other part of the disconnect. It's that act suggests that person is threatening an imminent breach of the peace. It's not that the act is threatening that there will be an imminent breach of the peace. It has to be reasonably perceived by others. The statute refers to physical activity that is reasonably perceived by others as threatening an imminent breach of the peace. It's the act that is threatening. It is not that the act is threatening a scenario where there may be a breach of peace. It's that somebody looks at the act and says that act is in fact a threat, and that threat is to imminently breach the peace. I think that's what squares it.
If that's what squares it, then we're going to have to work pretty hard to get some language that avoids the problem that's been the thrust of my objections, and nothing that we have on the pages here today is close.
Well,
I understand what you're saying, Judge, and I agree. It has to be Mr. Gibson or Mr. Schultz acts, not just their presence that causes.
Not only their act, but their act has to be the threat.
Right, exactly.
Right.
Would the court entertain a special instruction that makes it clear that incitement, right, this concern that we've had through jury selection?
I would certainly entertain.
Incitement of others responding is not contemplated by the right statute.
I think that's a correct statement of the law, so I would entertain such a special instruction. For present purposes, violent and tumultuous conduct will be defined as physical activity that reasonably is perceived by others as threatening an imminent breach of the peace. And again, the reason, just to make a cleaner record, because we went back and forth a number of times, the reason I believe that does not implicate First Amendment concerns is because the physical activity itself, under this definition, must be the thing that is posing the threat of a breach of the peace. It is not that others will react. It is that the act itself is the threat.
Can we put that
breach.
sentence as the very next sentence?
You are welcome to draft it and propose it, and I will consider it. We're going to move on for now, though.
Your Honor. Mr. Lee. Just an observation. One of the difficulties I think here is that we're defining a phrase, violent and tumultuous, instead of defining a word. And we don't have any instruction anywhere that simply defines violence.
I believe,
because I think we might benefit from a Webster's definition of violence. Right.
I will entertain a request for that, except I think we just covered it. Sure, we could. I mean, the Chakarian uses the Webster's Third International Dictionary's definition of violent as one characterized by extreme force, marked by abnormally suddenly physical activity and intensity, too furious or vehement to the. Actually, it's really just the first one, I think. The problem is, violence doesn't exist in the statute. Violent and tumultuous conduct. Turning to the definition of riot, the state has requested the uniform form of Uniform Criminal Jury Instruction 2301. Mr. Schultz has requested a modification. Mr. Schmatzies, what is?
Yes, Judge, it's based on the new riot case that came out in the matter of MAWS. It's a part of the Simon-Off progeny, which is elements in the criminal code need to have mental states attached. There was no mental state prior to Simon-Off for the riot statute in regards to sub 2.
So it includes. Your version includes the mental state of knowing.
Yeah, I think because this is there's a difference between a circumstance and a result, I believe, or a conduct and a result, and I think this definitely would.
Does the state agree that that's a correct statement of the law and necessary to the proper giving of this instruction?
I think we do. I think our indictment pleads it that way, actually, to be correct.
I agree.
But the pattern instructions haven't caught up.
Correct. Mr. Kalbaugh, a note for the committee. Does anyone, we'll get to Mr. Gibson's separate proposed instruction, but does anyone disagree that knowingly needs to be included in paragraph 2? Okay, so whatever form of the riot instruction we give will include the knowing mental element as to riot, as to knowingly participating and knowingly engaged. Mr. Gibson's proposed instruction is different how?
If you go to compare section 3, ours is the only one that in that element actually includes the requirement that the conduct thereby intentionally or recklessly created a grave risk. The statute uses the word thereby, creating the grave risk, and the other two instructions do not. So we're in agreement on element 2.
You just want thereby included?
Yes.
I think what's different is you wrote personally engaged in both sub 2 and 3, which I don't, that's not in the uniform.
Yeah, that's a Shakir, that's from Shakir.
Right. Yeah,
Personally, I don't need, because I think it'll be confusing. Of course, it says that Mr. Gibson engaged in, the personally is not doing any work, so we're not going to use personally. I'll do it over Mr. Gibson's objection. I think the two differences, well, two things. One, Mr. Gibson's instruction correctly includes intentionally or recklessly in the third element. Mr. Schmancy's and uses thereby, which we should use. Mr. Schmancy's correctly uses the knowingly standard in the second element. So what we're going to do is start with the state's proposed form.
With the state's proposed form.
And it should read Joseph Gibson, Mackenzie, Lewis, and Russell Schultz III. I beg your pardon, Mr. Schultz. While knowingly participating with 5 or more persons, comma, knowingly engaged in tumultuous and violent conduct, and then and 3. I won't read the 3 names again. By engaging in such conduct intentionally or recklessly. Okay, so the state has it right there.
Okay.
So
I'm gonna let you look at the screen to.
but we're going to add the word by engaging in such conduct, thereby intentionally or recklessly. Mr. Lee.
I agree with the court's critique of our individual instruction, but when we go to the state's instruction, and element 2 says Gibson, Lewis, Schultz, while it should say each engaged.
Agreed.
Was that added?
Nope. I agree with your comment in real time. Does the state agree?
Say it again.
Sure. So the idea is not to confuse the jury into thinking that this is a group charge, so that it should read, for example, in paragraph 3, Joseph Gibson, Mackenzie Lewis, and Russell Schultz III, each engaged.
Sure.
And that would, it's also going to apply to paragraph 2.
Follows this.
So would it be?
Yeah.
For paragraph 2.
Each engaged.
Each knowingly engaged?
So, okay, except the jury does not have to find, to find one defendant guilty, does not have to find that another defendant.
Certainly not. We've instructed them exactly that.
Okay, so the each you think therefore is not confusing on that point? We need something to account for Mr. Lee's concern. Right.
Okay.
Each defendant you find guilty must have blah, blah, blah.
Which is the way to do it backwards, right?
Sorry.
We're going to go off the record for a moment.
Okay, give me just 1 second.
Send this, okay.
We're off record.
So, yeah, I have absolutely no idea what they are talking about. We are gonna... I've got some feelers out trying to see if I can find information. And... Sorry, somebody was trying to check public cameras in the area, and apparently there's one owned by KGW down there that happens to have an error right now. Whoa. I do not know why they turned off the camera. Presumably they're going to turn it back on in a minute. Well, there's already 3 convicted because they pled. But that's what I was talking about before, is we have charges from protests downtown in 2020 where a single person along with a bunch of other charges gets charged for riot. But you don't have 4 or more other people also getting charged. Gonna have to look for that.
Why don't we just do it 3 times?
That's fine.
Yeah.
So three instructions of riot, 1 for each defendant, exactly the same in the form that we've talked about. Mr. Lee, that was a good catch. I appreciate it. I think the way to solve it is just to break it out. So does that make sense?
Individual instructions, I just wanna.
And I'll look, I promise.
Oh, no, that's okay, I just wanted to make sure I have the thing.
Right, so in the
form that we have it
we
there,
don't
but
need
just-
each because we're just gonna break it into.
And we'll just break it into each of them, and then it'll be names
So-
and the dates will be the same.
Exactly right. So what it'll be is, it'll read riot,
What we should do.
Joseph Gibson, and then the instruction, it'll read riot, Mackenzie Lewis, and then the instruction, and the same for Mr. Schultz. So,
And we'll get the thereby in there.
and the thereby will be in
And
there.
thereby is here.
Great. It's
and
hereby.
knowingly's are there.
Hereby there.
Good. Okay. Middle of page 21 is Mr. Schultz's request. I'm sorry.
I'm looking for my one jury instruction and I can't find it. On
Mr.
Lewis.
Doyle, your
Coming up.
version, the one you are referring to is, you had requested 10:30, so that is already up there. And then earlier, your instruction was similar to the riot one, and the only thing that was different than any of the things that were submitted by other counsel was that you had highlighted a portion of the comment, so that is not part of the language that is included in the instruction itself.
I see. I've got you. You're at the top of page 20, Mr. Doyle.
Oh, good.
And I understand you were requesting the term, or you were requesting that the jury be instructed with language from the comment from the committee that the term tumultuous and violent conduct is intended to represent more than mere loud noise or disturbance. The language designed to imply terroristic mob behavior involving ominous threats of personal injury and property damage.
That is correct.
Okay. I think my definition of violent and tumultuous is more correct. And so Mr. Lewis's request for that particular language is denied. Page 21 is Mr. Schultz's request for an instruction of violent and tumultuous conduct. Mr. Schmonses, would Mr. Schultz, to the extent I have told you what I'm going to instruct as to violent and tumultuous conduct, would you ask that that language be appended to that instruction? Or that this instruction be given separately with?
If the court's willing to give it, I don't think it can, I think it's a correct statement of law.
I agree. I'm just asking what you want to do with it now that I've already defined the term.
I'll ask that you instruct, Judge. I won't
Okay.
accept if you don't.
Does the state?
As a separate instruction or as in addition to the definition?
I think we already covered it, Judge, in our earlier discussion, did we not?
I think it is worth saying explicitly.
Yeah.
Okay.
I would propose combining it with the definition.
Okay, if we combine it, is there any objection to that language?
I'd like it to go after the sentence I emailed out.
Fair enough.
I would just,
But if you don't get that sentence, still there.
Access conduct and some words in the using, but.
yeah, can we just strike that is prohibited by the riot statute, just violent and tumultuous conduct?
Contemplates physical acts.
Yeah,
Yeah.
Not expression or speech.
yeah, and then strike the statute does.
Yep. What I would like to include though is the word only.
Okay.
Sure.
Violent and tumultuous conduct contemplates only physical acts,
Yeah, that's
not expression or speech. Okay,
And where,
we're gonna append that to 2306.
Just as a scheduling question, Your Honor, in case I need to make childcare arrangements, is the court thinking we'll work past 5?
No, I
Okay.
can't.
Thanks.
okay, so, got it.
Yep, except we're gonna change the language, so violent and tumultuous conduct.
Oh, yeah, when I tried to,
Yeah,
it's only physical act, not expression of speech.
Right. But not, so the whole, we're gonna start striking from that, we're gonna strike that is prohibited by the riot statute. All of that is coming out.
There you go.
We will come back to it. We're gonna come back to that sentence that Mr. Buchal is requesting.
So then to clarify, Judge, we will not include the violent and tumultuous conduct language down here.
Correct. We can strike that. Mr. Sponsees, I understand you agree with the inclusion of that language as modified?
Yes.
Okay. Does anyone object? That language will be included. Understanding that Mr. Buchal wants to, or Mr. Gibson wants to add another sentence, which we will come back to. Mr. Gibson separately requests a definition of violent and tumultuous conduct. It's similar and in fact, I think overlaps with his earlier. I'm going to overrule that over and not give it over Mr. Gibson's request. Okay, this is Mr. Gibson's instruction that actually has the same language that I denied Mr. Doyle on, but I'm happy to hear additional argument.
Yeah, all I would say on that is that the term, if you go on YouTube and you type in riots, okay, you'll get an awful lot of events in which an awful lot of people are killed and things are set on fire and so forth and so on. And so there's a sense in which the state is pushing us very, very far away from the normal common definition of riot to, when you say anything that threatens a breach of the peace, we don't have a.
It's not what it says. That's not what the instruction says.
That's good.
Well, I thought Your Honor talked about
It's a physical act.
Activity reasonably perceived as others as threatening an imminent breach of the peace. And so the average juror, when they hear breach of the peace, is, a loud noise at 10 o'clock. It's just so far disconnected from the word riot that I think we are losing the fundamental intention of the legislature here, which I think is better captured in the state versus goodwill language. And so somehow we're just getting way far away.
Okay, all right, I hear it. And Mr. Doyle, I'll revisit my earlier overruling of your request. The state's position?
We object, Your Honor. I think the Oregon law and the criminal statute of riot may not necessarily be what people associate with the term riot or what they see on YouTube when they search riot.
But this, of course, is coming straight from goodwill. What it's actually doing is quoting the Oregon Criminal Law Revision Commission and then saying, after the quote, the above explanation of the statutory language provides an adequate standard for judicial and jury determinations.
I think the better guidance comes from the Oregon Supreme Court almost 20 years later.
I took my comment right from the uniform.
Yeah, so really what this is defining is what breach what is the, so it's not
The peace is intended to represent.
We could say the breach of the peace involved must be more than mere loud noise or disturbance. It is intended to imply this.
I think in the 21st century, terroristic is too loaded to work here.
The only reason I disagree with you, Your Honor, is because so many jurors on their questionnaire referred to our client as a terrorist or the terrorist organization. So the common usage has evolved a bit, I think.
Understood. Notwithstanding that, I am going to give the instruction, but with the modification, I'm removing both terroristic and mobbed Terroristic for the reason I just identified. Mob, because in the context of, as we keep emphasizing, in the context of a riot charge, the question is, what did this person do? And the way you get to riot is you add up person 1, 2, 3, 4, and 5. Otherwise, I think this is a correct statement of the law, and I think it will be useful. So what we are going to do is we are going to pull this language back into that same definition section that we had before. And then, yep, right there. And then we're going to write, quote, the breach of the peace. No, I'm sorry. We're going to go back to what you just put in. So the term tumultuous. We're going to the term, quote, breach of the peace.
The term tumultuous?
Nope. The term
breach of the peace. Understood. Thank you.
And instead of is intended to represent, because that's bad English, represents.
Yeah, I understand what you mean.
We're going to get rid of the is before. Good. Represents more than mere loud noise or disturbance. It means. Yep. Behavior involving ominous threats of personal injury and property damage. I think that's a correct state of the law. I'm going to want to think about it a little bit, but I think that's right. Do folks want to state objections now? Please go ahead.
Well, I wonder now if we should define personal physical injury. Well, maybe not. I don't know. I'll think about that. Nothing to say right now.
I'm likely to think it means not understood in its common sense.
Right.
Mr. Gibson has requested also next a definition relating to the term tumultuous and violent conduct does not include political speech or protest. We have already put in Mr. Schmanzi's language that it doesn't include speech. It only refers to physical action. Therefore, I think Mr. Gibson's request is redundant of that. I prefer Mr. Schmanzi's language.
Can we add protest to Mr. Schmanzi's addition?
Vocal protest? Right, an act of physical protest could qualify. So
Violent and tumultuous conduct that contemplates physical acts. It does not criminalize expression or speech.
And actually, we didn't use criminalize. I took out criminalize. It does not include.
We're trying to get the concept of political speech or protest in there because that is the area in which the greatest latitude is given. This is the area.
But we are already so carefully defining it as a physical act, right? A physical act of protest is not protected in the way that a speech.
Well, that depends on whether it's expressive conduct.
I agree, and it's not. When we say because of Mr. Schmanzi's, it does not cover expressive conduct. Can we pull up that definition?
It doesn't say expressive conduct, I don't think.
I'm sorry, I thought it did.
That's okay.
And I'm still requesting mine. I don't know where we can fit it, but.
So I have agreed to give a version of yours, I have removed terroristic and mob, but I've included the rest of it. I understand you're objecting to my removal of those words, and over your objection, I am removing.
But it'll still have tumultuous and violent conduct. It's intended to represent.
I'm sure if you look at the screen, Mr. Doyle.
Okay.
That is, and
Right up there.
can you accept changes for a second?
Yeah.
Just accept them all now and then undo it afterwards.
Or you can view no changes, that also.
That's a good idea.
I'm just going to recenter it. We're not going any further.
In any event, we were focusing on the notion of expressive conduct, which unfortunately is not covered in the second sentence.
So how about instead of not expression, not expressive conduct or speech?
Okay.
Which I think is a correct statement of the law. So instead of expression, expressive conduct, which obviously the Oregon courts have expressly have
We need to define that.
specifically ruled out.
Right. I think that's gonna lead us to needing to define expressive conduct in a subsequent instruction.
Okay, I will consider such an
Yeah,
instruction.
I'll get that going over the weekend.
Okay, and so Mr. Doyle, the remainder of your the version of your instruction that you've requested is there. I understand it is not in exactly the form you wish, and I'm insisting on this form over your objection.
Thank you, Your Honor, because
What about maximum protection for political speech?
Well, that's the next one.
Yeah, I was trying to get us along.
When you raise it, Mr. Schmantzes, do you take a position?
I like it, Judge, if you're inclined to give it.
I'm not inclined to give it because the jury is now being told repeatedly that it cannot punish speech or expressive conduct. So it doesn't have to maximally protect political speech because speech is not a basis on which it may convict any defendant. If Mr. Gibson stands on his request, that's fine. He does stand on his request. I am denying giving this instruction over his request.
and I'll join.
I am also denying Mr. Lewis's request. Next is Mr. Gibson's request relating to protection of public advocacy.
I'm also asking for that.
I'm joining.
What do we do with the time, place? I mean, it may be true sometimes, it's not true other times, right? Sometimes you can't protest on a sidewalk in view of a constitutionally valid time, place, and manner
That's not
restriction.
raised by the facts of the case, Your Honor.
Yeah.
Disagree. I don't know if it's a fully accurate statement of the law.
As it relates to this case, if the event had gone on into the
Right.
wee hours of the night.
That's commenting on the evidence, though. That's instructing the court.
Yeah.
Or instructing the jury with commentary on the evidence. I still think this is unnecessary and confusing in light of the way we've defined and repeatedly and strenuously stated that speech cannot be a basis for conviction.
The issue, Your Honor, is that the extensive questioning of the veneer revealed a wide variety of conceptions and misconceptions of the constitutional rights involved. The jurors will go in there with a view of constitutional law, which is far beyond that just a reference to speech does not rule out the evident juror misconceptions about constitutional law that we heard. So we have to go
cure those misconceptions with an inaccurate statement of the law.
And I don't think the misconceptions are relevant when the jurors are going to follow the court's instructions, which will cure any of those concerns.
I think that's right. I think the instructions as prepared address this issue. Mr. Gibson's request for protection of public advocacy as joined by Mr. Schultz, and I think as I heard joined by Mr. Lewis, is overruled. The instruction will not be given. Next is defendant Gibson's special request for jury instruction with respect to offensive messages. I anticipate ruling similarly, but if you wish to make an argument.
once again, context where there are such powerful dispositions to regard certain types of speech as not being protected speech on the part of the veneer. This is an important First Amendment principle, and it addresses some of the juror attitudes. If the state feels that it is pushing the jury too far one way or another, that can be cured by additional language. But the importance here is that Mr. Gibson was appearing in a place that was a public sidewalk, public forum. That's why we had the form charge that we skipped over earlier. And it's important to bring in the concept that that if the jury, finds speech here, this is the place to do it.
I understand the argument. The record is made. The request is overruled because this jury will be instructed that can only consider actions. It cannot consider messages or speech or expressive conduct. I don't believe this jury instruction is helpful. I think it will confuse the issues, confuse the jury. And Mr. Gibson's request is denied.
Just briefly, Your Honor, I'm still concerned that walking on a sidewalk will be considered the action. And if we could just take the last portion, if we could just offer public sidewalks and streets or other public places, our public forums where one can exercise political activity, something along those lines. I think that goes a long way to our concern about wrongful conviction based on walking on a sidewalk.
This isn't a trespass case. Getting into instruction on whether the sidewalk is public or private is confusing, and it cannot be violent and tumultuous the way it's been defined.
I agree. The state is prohibited in this case from suggesting in any way that Mr. Gibson was not entitled to be on the sidewalk. The state may not infer it, may not suggest it, may not argue it. That said, I stand on my earlier ruling. This instruction will not be given for the reasons I've earlier stated. Bottom page 23 is Mr. Gibson's special requested jury instruction relating provocation and free speech. Again, I have removed speech from this case, or I've ensured that speech does not enter this case. And for that reason, this instruction will not be given over Mr. Gibson's request that it be given.
This next one, Your Honor, at the top of page 24 goes back to the missing sentence that I emailed to
Okay.
Ms. Lou.
Let's take that up then. So Mr. Gibson is requesting, as we've been working through our violent and tumultuous conduct definition, Mr. Gibson is requesting that the following sentence be included after the first sentence. The defendant's physical activity itself must be the threat that poses the risk of breach of the peace, not the reactions of others to that activity. Did I say? I said that.
Yeah, you said that.
Well, I thought we had already appended something almost exactly like that.
I said it. I didn't actually make it in. The clerk will pull up the current version of the violent and tumultuous conduct instruction.
Okay.
Can we at least add it means behavior involving ominous threats of personal injury and severe property damage instead of minimal property damage? I mean, if I accidentally, something, there's going to be property damage, but this is more than that.
But the Goodwill case just says property damage.
I agree. That request is overruled. As to Mr. Buchal's request that we amend the violent and tumultuous conduct instruction to read, violent and tumultuous conduct, it should say means, physical activity that reasonably is perceived by others as threatening an imminent breach of the peace. Mr. Buchal would then add, the defendant's physical activity itself must be the threat that poses the risk of breach of the peace, not the reactions of others to that activity. They would then continue, violent and tumultuous conduct contemplates only physical acts, not expressive conduct or speech. The term breach of the peace represents more than mere loud noise or disturbance. It means behavior involving ominous threats of personal injury and property damage. Any objection to including that second sentence?
No.
I agree. And so that will be included. Mr. Buchal, with our inclusion of that in that sentence and that instruction, is Mr. Gibson standing on his request for his mere words insufficient instruction?
We would stand on it for the reason that it includes the concept of insulting or opprobrious words.
Thank you.
But other than that, we've picked up most of it.
Okay. Again, having with that instruction removed all speech from this jury's consideration as a basis on which to convict any defendant, I do not believe this is an appropriate instruction. It will not be given over Mr. Gibson's request that it be given. Next is Mr. Defendant Gibson's request for an instruction on coercive speech protected. I'm not sure I understand it, but I do understand that it's grounded in speech.
That is true, and I would stand on it and say that it's disposed of by Your Honor's prior ruling.
Stands on the request. That request is overruled. The request will not be given in view of my earlier rulings relating to speech. Relating to expressive conduct, is Mr. Gibson satisfied with the use of expressive conduct in the earlier definition?
That covers it, Your Honor.
Okay. Understanding Mr. Hughey's point, which is that the state might wish to have expressive conduct defined. But I understand that that particular request is withdrawn by Mr. Gibson. Next is Mr. Gibson's requested special jury instruction relating to content and public alarm. Again, this is a request grounded in speech.
The only thing I would say about that is, even if we don't need the entire thing, it's focused on a different element, the element of grave risk of public alarm that we sort of haven't come to yet or haven't talked about yet. And I think that in particular, the last sentence of the first paragraph of the instruction is important in defining, when we discuss grave risk of public alarm. I think also that we stand on the instruction and we think that the concepts need to be jammed in somewhere, if not here.
And I'm sorry, the foundational concept is that?
The foundational conduct is that when assessing the grave risk of public alarm element, in addition to the violent and tumultuous conduct element, we have to strip out the content of the expressive conduct.
Okay, I think I've done that.
I don't think we have another public alarm instruction. But maybe I missed it.
Well, but that's where Mr. Lee's thereby comes in, right? It's by engaging in the non-speech, non-expressive physical act that the person intentionally or recklessly creates a grave risk of public alarm. I think the operation of the statute there actually works.
Let me try one more thing that's addressed at the second paragraph, which is at a different concept, which is Mr. Gibson was attempting to, in some sense, raise public alarm about the nature of Antifa,
right,
and the fact that there was a nest of Antifa here in.
I hear the point.
Okay.
I'm going to deny the request. I understand there's some nuance there, and I think I'm with you on understanding what that nuance is. The issue is because the only thing that may be considered in Mr. Gibson's case is Mr. Gibson's physical conduct. There is no way for the jury to reach the substantive issue because his conduct was not expressing any of those ideas.
No, the issue is that if he goes to a bar for the purpose of raising public alarm about the nature of the inhabitants of the bar, the jury could find that the element was satisfied because the public should be alarmed about Antifa. And that's what the second paragraph is aimed at stomping out.
But that's where thereby. That's where the violent and tumultuous act, which thereby intentionally and recklessly creates a grave risk of creating public alarm. Mr. Gibson is privileged to do many things. He does not enjoy the right to engage in a tumultuous and violent physical conduct and to thereby intentionally or recklessly create a grave risk of causing public alarm, because that's what, if you do it with 5 or more people, that's what riot is, right? You're suggesting that if his intent in doing that is to raise an awareness that excuses what would otherwise be criminal, and I don't think that's right. I assume there's a state. I've stopped asking if the state objects, assuming that it does.
That's right.
Okay. Yeah, I hear it. I think it is legally infirm. And Mr. Gibson's request is noted, but the content and public alarm proposed special instruction will not be given over his request that it is given. I want to do this. Boy, we are very close.
Your Honor, I was going to approach the bench before with this. I'm assuming that.
I'm in contact.
Kenny, why don't you wait on that? We don't need to talk about that right now. We got to get through the jury instructions.
Okay.
We're not gonna get hurt.
I'm in contact with the sheriff's office.
Okay.
Next is Mr. Gibson's request, and Mr. Schmuntzy's. I thought we were going to have one from you as well, which if we have it, I don't see it, is request relating to a specification of riot, violent and tumultuous conduct. I'm sorry, the thing that I was focusing on was there's a concurrence element to this instruction, and I think the concurrence element needs to be included somewhere. So the question is whether
Judge, mine's on page 28, line 18.
okay, thank you. Let's consider these two together then.
Mr. Schwanz's concurrence, yeah.
Any objection to Mr. Schmuntzy's concurrence instruction?
There is not an objection.
Let's put a pin in that and go back to Mr. Gibson's request on page 25 relating to specification. Essentially, this is the election instruction.
Yeah.
Okay. I'd like to hear from the state on that.
Right. We maintain the position that the conduct that is criminalized is captured in the entire episode. And, you know, this footstep, this arm motion does not have to be spelled out in the jury instructions.
Okay.
And our position is that the Oregon Constitution, the United States Constitution don't permit the state to lump in the speech and non-speech components in that fashion, because notwithstanding the jury instructions, the precedent that we have cited says that you don't let that go to the jury because of the risk that the jury is not the one to draw the First Amendment lines. It is for the court to draw the First Amendment lines. We've been sort of waiting for that for several years now, and the state is still in the position of throwing the whole thing in and letting the jury draw the First Amendment line.
I believe the line's been drawn. I believe the line's been drawn in my insisting on an instruction that excludes all speech and related conduct from this jury's consideration when it considers whether any of these, each of these defendants is not guilty or guilty of the crime of riot. Because of that, I don't think this instruction is necessary except for the concurrence portion. And so would Mr. Gibson yield to Mr. Schmuntzy's concurrence instruction?
It requires some rewriting to make it general to all defendants.
Oh, sure.
Right. Yeah.
How about Mr. Schmuntzy's version of the concurrence instruction as, in order to find any defendant guilty of the crime of riot, each and every juror must agree on the underlying physical acts that constituted violent and tumultuous conduct as that term is defined. For example, if 10
That's not written well, I apologize.
If 10 jurors, I think is what that's supposed to say, if 10 jurors believe that a defendant engaged in riot by committing Act A, and 2 jurors believe that defendant engaged in riot by engaging in Act B, you do not have a sufficient concurrence for a lawful verdict.
We don't like it because we believe it has the characteristic of shoving the jury toward the conclusion that the defendant did something riotous. We like our last paragraph better because it does not push the jury into saying, yeah, this 10 jurors believe he did this thing, and 2 jurors believe he did that thing. It's better to have a more general implementation of the concept.
I think the concern that Mr. Buchal is expressing is that the concurrence instruction on behalf of Mr. Schultz could be read as a comment on the evidence, indicating that there are...
What if we just use the first sentence of Mr. Schultz's?
That's not specific enough, Your Honor.
In order to find a defendant guilty of the crime of riot, each and every juror must agree as to which underlying physical acts constituted violent and tumultuous conduct, as that term is defined.
Can we add which underlying physical acts were committed by that defendant that constituted?
In order to find a defendant guilty of the crime of riot, each and every juror must agree as to which.
I was gonna say something as to that all elements, each juror must agree as to which juror as to all elements of the crime of riot.
The problem is that elements is overly, the problem with that is the jury might then feel that they can disagree as to which conduct was violent and tumultuous. So I agree with that notionally on the broad scale, but we need to be more specific. Allow me this. In order to find a defendant guilty of the crime of riot, each and every juror must agree as to which underlying physical acts committed by that defendant constituted violent and tumultuous conduct.
We add the word specific before underlying physical.
I think which does the work. In order to find any defendant guilty of the crime of riot, each and every juror must agree as to which underlying physical acts committed by that defendant constituted violent and tumultuous, etc. Any objection to that language?
No. We continue to.
Yes, to which?
As that. Yeah.
I still think specific acts.
What's the difference between which underlying physical acts and which specific underlying physical acts? What is the difference between those two clauses?
I think jurors would appreciate the word specific and a little more than
Fair enough.
Than we all would.
I accept Mr. Gibson's preference. I overrule it. That will be the form of the instruction. Any other objections?
We prefer stand on the original. It's overruled. We understand.
Very well. Mr. Schmantzis, I've edited your work. Yeah. Okay, no objection. Any objection?
I still think that comment makes this a much clearer case, and the reason for the specific elements are that their language has to do with, you know, the difference between intent as to some and it also relates to the best evidence. I mean, this is a very complex case, and the more instructions that we do to do it once will help the jurors to figure out what's going on, because we have 3 defendants and we've had, you know, they know that there's been lots of people and lots going on, and I'm just concerned that if we streamline the instructions, we sort of, I know that we're not supposed to use this phrase, but we're down a slippery slope to guilty. You know, it just makes it so much easier for them to.
I understand by Mr. Doyle's comment that Mr. Lewis objects to that form of the concurrence instruction. That objection is overruled. That form of the concurrence instruction will be given.
Second concurrent instruction is at the top of page 26, the one on the group.
We can call it, let's do this instruction and then we'll call it if that doesn't.
That's just fine. Okay. Thank you. Yeah, I would want to see authority that shows me that's right.
Judge, I don't know that that's correct. And I was.
Sure it is.
Huh?
Sure it is.
Identifying which 5 people?
I don't think they have to identify it. Well, I think they have to.
Oregon law says we don't have to name the specific other people.
So if one juror thinks, yep, you were doing it with people 1 through 5, they were also engaged, and the other person thinks you were engaged in 6 through 10.
Yeah, I'm convinced.
Well, it wasn't my finest moment, but it was good enough for Mr. Hughey.
No.
Okay. Any objection from any party to Mr. Gibson's request for the concurrence instruction on? Well, I'd like to call it concurrence, not unanimity, so it's similar with the other instruction.
I would propose combining it with the one we just did and just saying this includes the finding that the five people.
I think I'd like to keep the same language, but we can keep it as part of the same concurrence instruction. Would anyone object to that?
Just a paragraph below.
Yeah, first one and then.
Great.
Okay. All right, we're gonna have to call it there. We'll go off the record.
So we'll do selective prosecution.
We'll pick it up.
We're off the record.
Okay. Yep, they just completely shut down the whole meeting. Yeah, these are two of the deputy district attorneys. I know that, talking about mask coverings, there have been, and we especially saw it in the Swinney trial, where a judge could give permission for attorneys to demask. It helps with communicating with the jury, as well as being clear in what you're saying and everything. So I suspect that there's rules that are allowing them to be demasked when they're anticipating talking or something along those lines. I might wish they were wearing masks more, but I'm not gonna gripe about it. But yeah, it looks like probably gonna be planning on being ready for 9 a.m. for them to come back together. It sounds like it may not be until 9:15, 9:30, but I'll, as usual, I'll be prepped for earlier rather than later, because I'm going to have to double check to make sure that the updates to the stream I make over the weekend take and all that stuff. Yeah, I mean, that comment about Haley, there's been a lot of people that I've seen, what seemed to be pretty compelling evidence of stuff like in Gresham as well as downtown, and yeah, it's been kind of surprising that there haven't been complaints, but I hope either people start seeing more of the similarities between us instead of all the differences, or eventually something's gonna happen.